All right, y'all can have a seat. Good morning, everybody. Welcome back. Before we get started, did anybody talk amongst yourselves about the case, discuss it with anyone else, or do any research on anything about the case? Nobody says no. All right, when we were finishing up yesterday, the defense had rested its case. The state, if it wishes, can present a rebuttal case. State?
Judge, just very briefly state and call Eva Benefield.
You solemnly swear or affirm the testimony that you give will be the truth, the whole truth, and nothing but the truth.
Ma'am, same rules as last time. Just make yourself comfortable. Get about 12 to 15 inches away from the microphone.
Good morning.
Good morning.
Please state your name.
Eva Benefield.
Okay. And I just have a couple of questions for you. The first is, was your dad right or left-handed?
He was right-handed.
Okay. And I just want to show you a picture. This would be Defense Exhibit 24 that's been entered into evidence of your dad appearing to do a push-up. Have you seen that before?
I have.
Okay. And when was that picture taken?
That was taken in 2018.
And then I want to show you State's Exhibit 105. Can you tell me what this is?
That's a picture of my dad on the boat.
And when was this picture taken?
That was August of 2020.
And is this an accurate reflection of the way he looked in August of 2020?
Yes, ma'am.
Judge, I just want to publish it briefly. Oh, at this time I would enter State's Exhibit 105 into evidence.
Same objections?
No objection.
No objection. Proceed.
And right there. Okay. Is this the picture 105 that you just identified?
Yes, ma'am.
Okay. Thank you very much. I have no further questions.
You can cross, Mr. Taylor.
No question.
Can the witness be released from her subpoena?
Yes.
Can the witness be released? Can the witness be released from her subpoena?
Yes.
Ma'am, you're released from your subpoena. You're free to go.
Thank you.
Thank you. State?
State has no further witnesses. Thank you.
All right. All right. Members of the jury, at this point, both sides have rested their cases. That means that the presentation of evidence, testimony, and exhibits has come to a conclusion. If you remember when I gave you those preliminary instructions when we started, I talked about three things: listening to all of the evidence, hearing the argument of counsel, and listening to the law as I instruct you. At this point, we need to take a break so the attorneys and I can sit down, now that everything is done, and work on those jury instructions to make sure they're in final form so that I can instruct you on the law, you can hear those closing arguments, and then we'll release you to go and begin your deliberations. That does take some time. So, and of course, after we're done working here, I want to be able to give the attorneys a break as well to get ready for those closing arguments. So my plan is to, do anybody want to be heard before? So what I'm gonna do is give you a break. If I could have you back downstairs at the jury assembly room at 12:30, and then we're gonna get you rounded up and get you back up here and get going with, if you remember, it's gonna be some initial instructions by me on the law. The attorneys will have a chance to give their closing arguments if they wish. Then there'll be some final instructions, and then you'll begin deliberations. So remember, now that everything is done, please remember the rules. Don't discuss the case amongst yourselves until all of those things are done. Don't talk with anyone else about the case. Please don't do any research or watch any coverage about the case. All right, so we'll see you back downstairs at 12:30. Thank you. All right, you all can have a seat. As I was coming downstairs, Kelly handed me an email from the state with, I haven't had a chance to look at it yet.
Yeah, so you have a printed copy?
I do, I had to print out a copy for me.
Once I gave you last night, just in case.
All right, so
Not for the treasure.
I assume that this has all of the changes that we discussed yesterday?
Yes, to the best of our ability, yes.
All right. So let's go ahead and take a run through these. And Ms. Benefield, please feel free to share a copy with your attorney, look over his shoulder. So, Mr. Taylor, as we go through these, we'll take our time, just look at them. If you have any objections, additions, corrections, deletions, please voice them. State, even though you prepared them from the standards, if you have any objections, additions, corrections, or deletions, please let me know as we go.
Yes, sir, thank you.
All right. First, 3.1, any objection?
No.
3.2, statement of the charge, any objection?
No.
7.1, introduction to homicide, justifiable, and excusable.
No objection. You have to the second part. Under great bodily harm. Means great is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I object to that part. And I think particularly because of the nature of the facts in this case.
State.
It's a standard jury instruction, Judge, we'd be asked that it be read unedited.
Specifically, Your Honor, because of the unique facts of this case, that is to say, relatively minor bruising leading up to the crescendo of the actual event, I think to keep this instruction as it is to the distinct detriment of Ms. Benefield, because it's basically telling them that they can overlook what precipitated the final incident.
All right. I understand your argument. It is part of the standard jury instruction. It's not misleading in its nature in describing great bodily harm. It complies with Florida law and the statutes. I think it needs to be given as part of the standard instruction. So I'll overrule that objection. Other than that one, the rest of it looked all right?
Yes.
7.4, murder in the second degree.
It's the state's position that that part in yellow about sudden provocation should come out.
Judge, I'm sorry, I just wanted to also mention, in the May update to the jury instructions, they cut out the reference to mere bruises.
No, well, online, it still has, on the,
Do you have the Florida Supreme Court order on that?
I'm on the bar website, so.
No,
Oh.
defense. Do you have there'd be a Florida Supreme Court order. Do you have that?
I do not have it with me, no, but I believe that it was removed from the May update.
You have it right there.
I may have it, Judge. Give me 1 second.
Yeah, I'm gonna have to see it. The Florida Bar website still does not include mere bruising.
Okay, here, Judge.
Well, can you show it to the state first?
Well, this is a different instruction, sir. This is not homicide, this is just felony use of deadly force. That's a different instruction. That's the one that was updated in May. Murder, the introduction of homicide was not updated in May.
This is 3.6F, justifiable use or threatened use of deadly force. Court will note that mere bruises has been redacted.
All right, thank you for letting me review that.
Just to make sure we're clear, the old version of self-defense read exactly like the new version. It wasn't taken out in 2024. That was not the parts that were amended. On 3.6.
All right. Again, I appreciate the argument. It's a standard jury instruction. It's not a misstatement of the law. I'm going to give the standard. All right, 7.4.
It's okay.
The judge, it's the state's position that there's been no evidence of sudden provocation. I'm sorry, heat of passion on adequate provocation. There was no evidence that a reasonable person would have lost normal control, would have been drunk. There was no evidence of a blind and unreasoning fury, so the state would ask that that section be removed.
Do you want the sudden provocation? Towards the bottom of 7.4, going to the second page.
It's the yellow part.
I'm fine with it like it is.
So you want it in?
Yes.
And state you want it out?
Yes, I don't think there's been any evidence that entered to go to those facts. That portion.
Exhibit M. Three point three D, possession firearm.
Fine.
Great.
No,
3.4, lesser included.
Fine.
7.7, manslaughter.
Fine.
3.3A, aggravation of manslaughter with a firearm.
Acceptable.
All right, 3.6, justifiable use of force.
Yeah. Which one? Yeah, two small tweaks.
I'm sorry, which instruction are we on?
3.6F,
Oh, okay, that's what I thought.
I wonder if the court would consider under the second part, giving an instruction on imminent, what imminent means. The instruction as is reads, the danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real. We could provide to the court a definition of imminent, but we'd like to have it.
all right, do you have it? Do you have a proposed jury instruction?
I'm not prepared at this point to tender it to the court.
Well, this is the final charge conference, so I'm going to need it.
Give me a moment, Your Honor.
Yes, sir.
Okay, here's one that we had, Judge, in preparation. I'm trying to keep up with all the paperwork. Let's do one without. Your Honor, I'd also like to request, if we could, adding a definition of great bodily harm in the deadly force definition paragraph.
Where did that definition come from? Immediate.
I think it might have come from case law.
It says it comes from Webster's Dictionary. The state objects. Number one, that the definition does not make sense to the state. Number two, I'm on Webster's Dictionary where it says it comes from, and that is not the definition provided by Webster's Dictionary. It's partially, it's parts of the definition, but the Florida Supreme Court has not felt the need to define imminent. I think imminent is a word that is commonly understood by these jurors, and the state would object to adding that definition or changing the definition of great bodily harm in this 3.6, which I think was his second request, which it's in the second paragraph. Great bodily harm means distinguished from slight, trivial, minor, or moderate harm. That second paragraph.
We're not asking the court to change the definition of great bodily harm. We're just asking Your Honor to add it in that paragraph as well.
In which paragraph?
Under 3.6F, the second paragraph, where it defines deadly force, means force likely to cause death or great bodily harm.
The very next sentence is the definition of great bodily harm.
Well, it's got a definition of great bodily harm.
No, it's not.
But actually, my copy has an explanation.
That's the,
Right, it's
that's the standard.
from the standard.
Yeah. Okay.
And then was you asked for imminent, you made your arguments against it, rebuttal.
No rebuttal other than I don't see what the downside is to it. I don't see how there could be any prejudice.
Okay. I appreciate that. I've never given a definition for imminent, and I'm not saying my ruling is based upon, well, I've never done it in the past, why would I do it now? I've separately and independently reviewed your proposed definition of imminent. I don't find imminent to be a word not in common usage or understood by an average juror. I don't think it needs to be defined. It's not defined in the standard. So do you want this marked and put in? Because I don't think you read it in, so let me mark it to preserve. So this is defendant's proposed definition of imminent. Is today the 30th? All right, that'll be filed.
And Judge, I think we got ahead of ourselves in this instruction, so if we could go back. Under the paragraph on 3.6F, the first page, it says the law and justifiable use of deadly force is as follows. It's the state's opinion that that first section in yellow would come out because of where it says, but is not relying on 776.0131, which this defendant is relying on that portion, which is the very next portion, and is almost identical, other than it adds extra things about since she was in a dwelling.
Well, that's what we discussed late yesterday, so.
Yes.
You're in agreement?
Okay.
Yeah.
All right, so
I'm sorry,
that,
Judge, I didn't realize we made a decision on that.
well, I don't think we made a decision. I just rambled on and on explaining the difference between the two and the distinctions and why 7760122 and 7760312 differed than 7760131, but covered the same ground. Just one is general self-defense and stand your ground, and the other one is in your home. And I would think that the defense wants the in your home.
Yes, sir. So I think we would pick up after that law on just to, if she's in a dwelling, that portion.
Right.
Okay.
All right, here's where we're going to need to take a few moments to talk about the forcible felonies. And Mr. Taylor, I had written them down yesterday. Hopefully you saw, oh, there it is. All right, state yesterday, well, let me confirm with the defense. So on the actual self-defense instruction that we're going to use for the 776-013 subsection 1, I assume that you're going to want A and B?
Yes.
Okay. And then the forcible felonies you mentioned yesterday are burglary, felony bat, ag assault, false imprisonment.
Correct.
Are there any others?
No, sir.
No felony battery. I thought felony, did you say felony battery? Okay, I'm sorry.
That's what was requested.
Yes, I missed it when you just said it, Judge, sorry.
Burglary, ag felony bat, ag assault, false imprisonment. State, are there any of those that you want to agree with before I hear argument from both sides?
No, Judge.
You don't agree with any of them?
Well, I may agree with false imprisonment. I need to think through burglary still. I've been thinking through it for the last 12 hours or 16 hours, but I'm not sure yet on that one. So I just think there's problems with each one of them, and I'd rather if we could just go through them.
Okay. Burglary.
I think it's the classic remaining inside. The testimony, if the court recalls, from Miss Benefield was that when he spun her around in her effort to leave the home and block the door, she summoned the wherewithal to command him to leave now. You have to leave now. That would have revoked his license to be present, and as a result, at that point, he was a remaining inside burglar.
All right, well, that's not just the end of it. So I've got the standard instruction for burglary, which would need to be obviously modified, because I don't instruct them on the burden of proof. It's just the elements, for any of these forcible felonies, the initial portion is going to be the elements of or for the forcible felony of burglary are, and then it'll give the elements. But if you, on the burglary, under 2, there's 2A, B, or C, so I need to know which one of those you're arguing. And based upon what you just argued, I'm assuming that you want 2B, as in Bravo, that would be essentially 2 would be Doug Benefield, after entering the structure, remained therein after permission to remain had been withdrawn, and with the intent to commit, there has to be some crime alleged, right? Because it can't be burglary or trespass. Or it could just be an offense other than burglary or trespass inside the structure. I need to know what you're proposing.
Give me a moment. Yeah, I think we would prefer other than, Your Honor.
All right, State, now it's, and are you asking for any other portion of the burglary statute if it's to be given?
Give me just a minute, Your Honor. Judge, can I see the instruction the court is referencing?
It's 13.1. 13.1 burglary.
Yeah, we're having computer problems, Your Honor.
I think the internet just came back. It was down.
Okay. Right, here we go. All right, what was the court's question?
On the burglary
Yes, sir.
instruction. So we've nailed down the elements that you're asking for. I'm asking, is there any other portion of that, before I go to the state and get their argument, is there any other portion of 13.1 burglary that you're requesting?
talking about, I just want to make sure we're talking about the same thing.
No,
Two,
so
A, B, or C?
the court is giving 1 and 2 had permission or consent to enter, and 2 after entering remain therein.
Yep, and then I have to give A, B, or C
Okay,
as appropriate. And I'm sorry, that's A, B, or C. Can be in the conjunctive or the disjunctive.
all right, we would request B and C, Your Honor.
All right, and on C that you're requesting, is it just to commit or attempt to commit a forcible felony?
Yes.
Which potentially will be.
You're-
Now, any other portion of that instruction before I go to the state? Or you state, whenever I get over to you, if I do decide to give it, if there's any additional portions, be prepared to argue those.
No, that's it, Your Honor.
All right. Okay, that's it, state. So they want, defense is asking for that. Are you looking at the standard for burglary?
Yes,
So it's on the second page,
yes, sir.
and if I give it, it'll essentially be something along the lines of, the elements of the forcible felony of burglary are 1, 2, B and C. On B, of course, the conveyances would be struck. B would be after permission to remain had been withdrawn and with the intent to commit an offense other than burglary or trespass inside the structure. C, of course, there'd be an or. C, commit or attempt to commit a forcible felony. So obviously you object to that, but if I am going to allow it, is there any other part of this instruction that you would want to be given?
2 paragraphs. Oh, let's see. It says the next paragraph is about intent being an operation of the mind. The following paragraph says, even though the unlawful remaining in a structure is proved, and I know we're not supposed to talk about proof, so I don't know how we would word it. If the evidence does not establish that it was done with the intent to commit a crime, other than burglary or trespass, the defendant must not be found guilty. I don't know how we would word that because I know we don't have proof, but I think that is an important.
Good news, I have suggestions.
Okay.
All right, so the state, in addition to what you're requesting for the elements, is asking for those next 2 paragraphs to be given, which explain intent. And I only had, when I say I have suggestions, this comes up in, I don't want to say every self-defense case, but so many of them, I have language that I've used in the past.
Yes, sir.
All right, so here's what I propose it would sound like, and everybody can object, because you don't want it, you want it, but you might not like the language, but I've given it before and it works. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Here's where the changes are because we're not saying proof beyond a reasonable doubt or anything like that. Here's where I've made changes. Even if an unlawful remaining in a structure is proved, if the evidence does not establish that it was done with the intent to commit an offense other than burglary or trespass, then a burglary has not occurred. That's what I've said in the past. And it just, it's an accurate, I'll hear your arguments, but I found that it's an accurate statement of the law, because the other way is the defendant must be found not guilty. That's not what we're talking about here. So it's just letting them know that what intent is and how that portion of the instruction operates.
Yeah, that's fine with us, Your Honor.
All right. Do you need that, State?
I will need that. And I can say, based on the conversations we have, I don't have an objection to the instructions as you've crafted them.
All right.
I will need to,
Oh, I'm sorry, and we also need structure, because structure is not defined in any of the other instructions. And that's on the very next page.
I
All right, Mr. Taylor, what I've done is I took the standard instruction and have amended it in my own hand as I've read. Do you mind if I give this to the state so they can take it back and make it part of the instructions?
No.
All right, thank
Does
you.
that include the elements portion too?
Yes.
Okay, sorry, I was trying to do it
Yeah.
as you were talking, but I wasn't keeping up.
My penmanship is horrible, I
That's fine.
apologize.
This is perfect, Judge, thank you.
All right. So that's what I've approved for burglary. Let's talk about false imprisonment next. And that's instruction 9.2.
Judge, I had one thing before we leave. On the last portion of 3.6F, justifiable use of deadly force, I wanted to ask the court to substitute 2 words in the final section.
I don't think we've gotten there yet.
We not gotten there yet?
Not to the end of the instruction. We're still doing the forcible felonies portion. Yeah. So the next forcible felony that the defense has requested is false imprisonment. So 9.2, if I give it, again, it'll begin with the elements for the forcible felony of false imprisonment are. So which one of those elements or methods by which one is falsely imprisoned do you think the evidence supports, Mr. Taylor?
We would like to have confined and restrained.
Just those two?
Yes, sir.
Okay. And also on number 1, it would need to read Doug Benefield forcibly, secretly, by threat. Which one of those?
Forcibly.
So you're not asking for secretly or by threat. That actually make it easier because secretly has to be defined.
How about forcibly and by threat, Judge?
So it would be or. And that means we would not need secretly. All right, state.
The state would object. There is no evidence at the time in which Ms. Benefield used deadly force that Mr. Benefield was preventing her from leaving. If there was a time in which there could be argued a false imprisonment, it would have been when she tried to get out the door and claims that he spun her around by her arm. But there was no evidence that once she was in the bedroom, there was any effort to forcibly or by threat confine or restrain her without her lawful consent, so the state would object.
All right, rebuttal.
Well, actually, I believe the testimony was that when she turned around, he was standing in the middle of the doorway, blocking the exit to the room.
All right, I understand completely that each side has their own theories and thoughts and not versions of the facts, but view of the facts. However, the facts as presented by the defendant do support the giving of this instruction. False imprisonment, here's how it'll read. The elements for the forcible felony of false imprisonment are Doug Benefield forcibly or by threat confined or restrained Ashley Benefield against her will. Doug Benefield had no lawful authority to do so. That would be the end of that instruction. As I review the rest of it, the rest has to do with certain enhancements.
Are you giving me that one too? Are you gonna give me that one too?
I would ask.
If not, I'm gonna need you to repeat it.
Yeah, no, my plan is to, after I do this, give them to you, because then it's all,
Yes, sir, thank you.
I'm sorry to put that on you, because
No,
I know
it's
you're
okay.
objecting to it, but,
It's on her. It's on her.
all right. Anything else on false imprisonment? So I am going to give it as I just read.
And
Okay. Yes, we would request a specific definition of the term false imprisonment based on the case law Proco versus State, if I may.
A definition of false imprisonment?
Yes.
the elements are there.
That, isn't that the elements of false imprisonment, is the definition of it?
This just lays it out, Your Honor.
Okay. Let me just, oh, yeah, go ahead and take a look at it real quick. State. Thank you. All right, did you want to be heard on this?
We object.
Right.
I think the elements are sufficient.
Any further arguments?
No, sir.
All right. I see where you pulled case law that defines and explains some of the factual scenarios that have been presented in various cases and whether those meant or equated to or violated the false imprisonment statute. But I don't think I would give a definition of false imprisonment in the false imprisonment instruction. It's false imprisonment, then you explain the elements, and then both sides can certainly argue whether those acts were or were not violative of false imprisonment. Do you want this one, Mark?
Please.
All right, so let me do this. Same thing, it's just my marked up version that I'm going to give them so they can,
Yep.
that way the typeface will all be the same. Thank you. For
Thank you.
instruction in false. Where to put this? There we go. How about aggravated battery next? I'm trying to take them in some semblance of descending order. Might not be perfect, but all right. Ag bat. So I guess what I'm looking for, defense, from you is what parts or portions of aggravated battery 8.4 you're asking for. It would start with Doug Benefield, A or B under number 1.
Judge, I think, frankly, after reviewing this instruction, we're going to withdraw the request.
Okay. So Agbat is withdrawn. Next one is felony battery. 8.5.
Yeah, we're going to withdraw that as well, Your Honor.
All right, felony battery is withdrawn as a forcible felony. And the final one that you had requested was 8.2, aggravated assault.
Requesting to be.
Well, there's a brief break. Everybody check your phones. Make sure they're on silent or turned off.
This
please.
one, I think, is viable.
You want to keep?
Yes, sir.
All right. And so let's look. There are some options, so let me go through them. So 1 is standard, 2 is standard, 3 is standard, but then under 4, are you asking for A or B?
B.
And what is the felony charged? The assault was made with a fully formed conscious intent to commit.
I think false imprisonment, Your Honor. Give me just a moment. I'm considering whether it would also establish any of the others. False imprisonment, Your Honor.
Sir?
False imprisonment.
Okay. State.
It's the same argument, well, it's a two-part argument, Judge. It's the same argument as to false imprisonment. I know you already were getting it, they're getting it, but I don't think that there's evidence that he made threats by word or act, I guess, other than "you're done," which the state would argue is ambiguous. At the time, the defendant Mr. Benefield appeared to have carried out the threat. I don't know what that means for this case, and the defendant created a well-founded fear of violence was about to take place. I mean, I think this is so akin to the self-defense argument that I think it's duplicative, but also to then say that assault was made with a fully formed conscious intent to commit false imprisonment against her. Their argument was just that he was already false imprisoning her when I don't know how you would put this in there, Judge, because he was already committing a false imprisonment, and then when he made the threat, he was then fully informed to commit another false imprisonment. I just think it's circular, and I'm not sure that it will make sense for the jury. I think it'll be confusing.
Like most of these things, it becomes a question of fact for the jury, and I'm not prepared to say precisely when, given those facts and the fluidness of the circumstances, when or for that matter, if the jury will conclude that there was a false imprisonment.
All right, thank you both very much. I'll give it. The question is, any other portions of that, or it's just the elements of that one? Certainly, there's no deadly weapon.
Or B. I think the first one, if the circumstances were such, that should be in. Deadly weapon is out, as would be an object not designed to inflict bodily harm. Great bodily harm is out. as would be Judge, not necessary that the defendant had an intent to kill.
Okay, you give this one to the state, so that'll be the last one. Those are, so we ended up with 2, right? 3.
And I guess, Judge, I'm gonna need some guidance on how to word this. Imminent commission of forcible, or burglary, comma, false imprisonment, like, that sentence isn't gonna make sense.
I'll give that to you.
Thank you.
All right, so I think it would need to say imminent death or great bodily harm to herself, or the imminent commission of burglary, false imprisonment, or aggravated assault against herself.
Okay.
It'd be in the disjunctive. And then immediately after that, I'll need,
Those in order.
yes.
Yes.
Thank you. All right, the next portion of what we need to discuss on the self-defense, we're still on 3.6F. We're through the use of force in the home. The very next paragraph talks about 782.02. This is the bottom of the second page of the state's, I think it's on the bottom of the second page.
Oh, I thought I took it out.
I think we talked about yesterday removing that, but let me make sure. The portion about 782.02.
I think I already took it out though.
I thought we did, but I have a question mark next to the one on my copy.
Oh, okay.
So I'm just making sure.
I have the next, just for clarity, the next paragraph I have after the ones we were just discussing is in deciding whether Ashley Benefield was justified, is the next paragraph I have on the one we did last night. Is that what you showed, Judge?
I looked at the wrong.
I had thought you had asked yesterday if we wanted A and B, and we said yes.
That's how we're talking about.
On which one? I'm talking about the portion that was 782.02. And like the state said, I have it, we weren't gonna give it, but then I have a question mark by it, so that makes me wonder if it was, we're not gonna give it, but we're gonna think about it.
Yeah, I marked it out, I have it, I thought. And
Again, I think that's what it is, but this could be just me having a question mark there for, I don't know why. But I just want to get confirmation on the record that we're not giving it.
C. Yeah, we'd like to have a judge, and we would request B and C.
any further argument?
Yes, this one.
No, Your Honor.
No.
In response to the court's question, did I have any further argument?
Okay. So, before I go to the state, because this is my question, if we're giving 776013 that talks about the approved or justified use of deadly force when one is in their own home or in their own residence or dwelling house, and including, and I'm going to give to prevent the imminent death or great bodily harm to herself, the imminent commission of those forcible felonies that I'm allowing, what are we gaining by adding 782.02? It seems duplicative to me.
It wouldn't be the first time that there's an instruction that overlaps.
All right, state, you want to be heard?
Yes, Judge. It's not an instruction that overlaps. It's repeating parts that are already in the instructions. The first paragraph is in 7.1, justifiable homicide, that almost the exact paragraph. And I believe the state's contention would be these are cases that are not when there's been a homicide, so you wouldn't have read 7.1. That's why it would be in self-defense when you use deadly force, but it's not necessarily a homicide. And so, and I think that to say B and C, that is exactly what you've already just read. And I do think it's duplicative, and I think could be confusing if we don't.
All right, final thoughts.
Nothing further.
I think I've shown that I tend to give instructions when they're lawful, they're an accurate statement of the law. The facts of the case support the giving of the instruction, and it's necessary to explain or clarify an area of the law to the jury so that they can do their job. However, when you look at what's being proposed under 782.02, that portion of the instruction, it is, while a different order, it's virtually identical. Subsection C talks about the commission of a felony upon Ashley Benefield in a dwelling house in which she was present, and that is taken care of in the instruction we're giving from 7760131. It starts, if Ashley Benefield was in a dwelling or residence in which she had a right to be, and then she's justified to use that deadly force to prevent the imminent commission of a forcible felony. So C is taken care of in what we're already given. And so is B, because it talks about committing a felony upon her, but doesn't talk about the dwelling house. So, quite frankly, we're already giving that. That wouldn't just be duplicative, it would be the exact same instruction being given twice. The 776.013 subsection 1 covers all of the issues and elements that have been presented. All right, the next one is then in deciding whether Ashley Benefield was justified. Certainly that's in.
Yes, sir.
And then we discussed yesterday, all of that middle part is out. And then the last portion,
Yeah, Judge.
yes.
they've added, if I'm not mistaken, they've added totality of circumstances to that paragraph.
Which paragraph?
In deciding whether Ashley Benefield is justified in the use of deadly force, you must consider the totality of the circumstances.
It says you must consider the circumstances of the time
And
the force was
they've
used.
struck by which he or she was surrounded. So totality of circumstances at the time.
Sorry, do you have that where it was?
Yeah.
Page 4.
If you just show that to the state first.
Those are proposed, that is not what happened. What's online is what happened. Those are proposals.
We didn't strike it. If you look at 3.6 as the Florida Bar has it, it's the same. That's a proposal to the subcommittee.
So we would like the proposed language.
Okay. Oh, so is that just a memo that you wrote?
It's the commission, it was when they proposed instructions
Yeah,
before they
this was
finalized.
from the committee.
So the committee proposed putting in totality of the circumstances, but it wasn't adopted.
Correct.
Okay, I got you.
We would object.
As the
Object.
court knows, the court's not married to the patterns any longer.
All right. Thank you very much for the argument. I think the standard jury instruction that we're dealing with adequately explains the law. It's not a misstatement. It's not going to mislead the jury in any way. So I'm not going to add totality of the circumstances. The jury is told you must consider the circumstances at the time the force was used. So I think it's sufficient. So that remains. And then if you look, then all that middle part is out. And then it goes to if you find that Ashley Benefield, who because of prior threats or difficulties had reasonable grounds to believe. Do you see that part?
I already took it out on the version I did last night, Judge, so it might be, I think he's working off the state's newer version. I took out everything you had already said.
Right, all that middle part is out. So it's going to go from you must, look at the circumstances that she was faced with, and then it has the part about you may consider and you should consider those prior threats and acts of violence that she knew about or was aware of.
So now I had on the penultimate paragraph,
Yes, sir.
rather than committed an act of violence, we would request that it read had committed acts of violence. You may consider rather than that, this. Based on the evidence, there's obviously more than one act.
All right.
Where exactly?
No, it's right.
The as you said, the penultimate paragraph, the next to last paragraph, and it says Doug Benefield had committed an act of violence. They want it to be acts of violence.
Oh, it does say or acts of violence on the standard, so we have no objection. I'll change it.
All right. Well, so do you want it to say an act or acts or just committed acts?
Acts, A-C-T-S, acts of violence, and you may consider this rather than that.
It's that fact in determining.
You wanted to say this fact instead of that fact?
Correct.
Okay. I don't know.
Plural as opposed to singular.
Sure.
That's fine, Judge.
All right. Anything else on 3.6F?
No.
State?
No,
Okay.
thank you.
3.7, any objection? It's got some horrible. Sarah, you're not writing down each sniffle, are you?
No snuffles.
Okay, thank you.
It's a lot. Have to make a new button. It's like that.
Hold on. So they left that out. Judge, I think there's a sentence missing on this one. Proof beyond a reasonable doubt does not mean proof beyond all doubt.
Where is that at?
It would come right before a reasonable doubt is not a mere possible doubt. I'm looking at the 3.7.
Which paragraph are you on? I'm sorry. Oh, okay. I found it. Oh, that's an update since 2024. There is an update.
Is that the only update?
Yes, that's the only request that I have as to that instruction.
Well, looking at that one, they've also added, no.
I'm still,
Is this one of the ones that just came out in May or July?
obviously our system has not been updated.
So if you look at the standard, are you on the Florida Supreme Court website? Is that what you guys are looking at too? It also has an addition, see right in about a third of the way down, the defendant is not required to present evidence or prove anything, which is what we've always had,
Right.
except for the defense of affirmative defense to the crime of relevant crime, as I previously explained to you.
I think that can apply.
Do you want to make an argument for or against defense?
Judge, would you mind if I printed while you're talking so that I can correct it for her?
Of course.
I just didn't want to be rude.
Yeah.
Yeah, so, it's interesting, Judge, because self-defense is an affirmative defense, but yet in the instruction, they don't acknowledge that. They just limit the instruction, or as a suggestion, insanity, reunification of an attempt, or rather renunciation of an attempt. No, I think that's confusing. I wouldn't request that.
This is interesting. I'm not even aware of any case law interpreting
Yeah.
this edition yet.
It's,
Because it's interesting, in state, I'm just going to throw this out there. So certainly, it's an accurate statement of the law. I think we can all agree on that, right? State has to prove beyond well, first it's a prima facie case, but proof beyond a reasonable doubt. Then there's the preponderance of the evidence that an affirmative defense, and the defendant has the burden of production and persuasion on it, but then the burden shifts back for the state to prove beyond a reasonable doubt the defendant did not act in. So it's interesting because this addition says defendant not required to present evidence or prove anything except for the defense of, but then doesn't talk about that burden shifting. I don't know. I wasn't on the committee. I'm on a different committee, so I don't know how I understand explaining, well, the defendant does have some burden, but then not telling them that it's a preponderance of the evidence, more likely than not, greater weight of the evidence, whatever words they wanted to use, but then the burden shifts back to the state to prove beyond a reasonable doubt the defendant's not entitled. So, do you want to be heard?
Yes, I think that we're asking for it. I think in Sandy and renunciation of attempt are examples, it says e.g. So I think it's well established that self-defense is an affirmative defense, and I don't know what legally would prevent it from being included in this instruction. And I think it is, as Your Honor has already said, an accurate statement of law. So we are asking for that paragraph to be included.
Not that this isn't difficult enough, but if the court does decide to add that, I think the court, in fairness, would be required to elaborate on the burden shifting back to the state, as the court just acknowledged.
All right. Thank you both very much. And certainly, whenever after I read the instructions and I charge the jury, I'll obviously ask if you have any objections to how the jury was charged. If it's just all the same previous objections, just renew your objections. Here's the reason I hesitate to give this right now. It's brand new, and I could be wrong, but I do have some concerns about how truncated it is with the actual nuances of the burden shifting that goes along with affirmative defenses and not explaining that. So I would feel some compunction if I were going to give this new portion of this instruction to explain that. At the end of the day, though, and remember, where am I getting to? So I could take that path with this new instruction, but going this way with just giving the instruction how it's always been, at the end of the day, the jury still has to find that the state has proven beyond a reasonable doubt the defendant's guilt, and proven beyond a reasonable doubt the defendant is not entitled to. So I appreciate everybody's arguments. I could be wrong, and I'll let somebody else get the case law on how this instruction is going to work now. So I'm going to leave it at the defendant is not required to present evidence or prove anything. You added in that additional sentence, proof beyond a reasonable doubt does not mean beyond all doubt.
Oh, I'm sorry, Chris, so you're gonna put a period after the defendant is not required to present evidence, or you're just putting a period there and leaving the rest out?
Yes, leave the standard that is the standard in my mind.
Yes, sir.
And then you added in that sentence at the beginning of the,
I printed out a new one for her,
Perfect.
yes.
any other changes?
No, sir.
State? 3.7 good?
No, nothing else,
Except for the objections about,
yes.
Yeah. that'll be interesting to see how that plays out. All right, 3.9.
No objection.
All right, perfect. Again, that's where I'm going to stop and then explain to the jury the verdict form. Any objection to 3.10?
No.
3.11?
No.
3.12?
No.
3.13?
No.
During that same paragraph, I talked. I'm so sorry. That same paragraph about during the trial, items were received, they'll be sent back. I do ad lib at that point because we have a tech cart that's right out here in the hallway. And when they go back to deliberate, they can play is it just the 911 call? Is that the only thing that's in?
Well, there is a DVD of text messages, if they wanted to,
All right.
read
They
them.
have a computer back there that has no access to the internet. It's just a laptop that is on the tech cart that they can use to view items or listen to items. So I do go off script there to tell them that. Also, up a couple of paragraphs from there, when I talk about the cell phones have to be, and electronic devices have to be left out. I also talk about smartwatches that can independently and separately communicate with the internet outside of Bluetoothing with another device, and that they have to leave their smartwatches with the deputy. All right, and then the verdict form.
No objection.
On the manslaughter, I thought the manslaughter was just,
We were just talking about that.
yeah, I think the manslaughter might need to be,
Sometimes we,
it's just one question.
Well, yeah. You mean breaking the questions up? I think it,
Right.
the state, this is the jury instruction we've been using because I think that it is confusing I think it puts too much emphasis on the separate charges if you break them up. And I think if they checked manslaughter and then 1, 2, and 3, there's no harm. We just ignore 2 and 3.
All right. Do you want to be heard on that? Because the factual findings are different between, obviously, the second-degree murder and the manslaughter for the sentencing enhancements and the 10-20 life.
Yeah, I don't have a problem.
You're okay with this one? All right, there we go. Not a problem if nobody objects. Well, if there's nothing else, then I'm going to let you all go. It's right about 10:30, so that'll give you 2 full hours. If you could, though, be back, maybe 12:25, 12:20, 12:25, so we can get the courtroom all set. Everybody can be ready to go. I can get the jury up here, and we can get started.
is there going to be a long J-way argument? And if so, when do we want to do
Oh,
that?
did you want to make one now, or do you want to wait until after we let the jury go?
You have to let them go.
All right. So the reserve on that. All right, y'all. We'll see you back in a little bit.
Thank you.
Okay. Thank you.
Good afternoon, everyone. We're back on the record in State versus Ashley Benefield, case 2020 CF 3014. We're ready for closing arguments and jury instructions. However, I've been informed that there may be a change or an error from earlier.
On 3.6, where it's the false imprisonment, I think your instructions said forcibly or, and you crossed out by threat, then you circled it, and I think we thought it was supposed to be left out, and just so it's typo, it says Judge Benefield forcibly or confined or restrained, because you've written or, I didn't catch it. So it's on the second page of 3.6F, and it's the first element of false imprisonment. And I don't know if we were supposed to say threat or not.
Okay. Let me hand out, thank you for doing those and sending them. The reason I'm late coming back, I apologize. The copier upstairs is moving just as slow as the internet today, so it just took forever to make these copies. There's one for each the state and the defense, and I want you to check. I saw that, and I think I fixed it.
We printed them thinking if you found it, we could at least just print that page, so.
Look and see. There was also a few punctuation issues that I changed, so a couple of commas.
She was typing away as best she could.
I really appreciate you guys putting that together for the standards. But look at 3.6F, I did catch that.
Yes, sir, I see where you fixed it, thank you.
Madam Court Reporter,
Yes.
here's a copy for you.
Okay, so we have one other issue, Judge. In 3.6F, when the court lays out the forcible felonies, we kind of feel like they lose their individual identity because they're not separated at all. And we were wondering if we could label them. For example, the elements of the forcible felony of false imprisonment are 2 dots, and then do the same thing with the elements forcible felony of aggravated assault are 3 dots. If you look at the instruction, the way it's printed, knowing that they're going to take it back into the jury room with them, it doesn't seem to have an individual identity. It just kind of is all lumped in there. So what I am proposing, may I approach?
All right.
I've shown this to Rebecca. Perhaps if we could just number them to give the jurors some sense that they're individual crimes. The only other thing we had, Your Honor, is the last paragraph on that page in deciding whether or not Ashley Benefield was justified. That refers to subparagraph A, and we were thinking it should come after subparagraph A, and then the rest applies to subparagraph B.
All right, State.
I don't care about the numbering. I think that they're fine. I think Mr. Taylor's welcome to explain it in closing. I think it's clear they're each labeled what they are, and you have them in a sentence. We have them in a sentence. As to that paragraph, I don't think that paragraph actually goes to A or B. It's for the self-defense instruction altogether. It's not as to that one section A or B, the last paragraph on page 2 of 3.6F. So I would just ask that it remain where it's at.
All right, final thoughts? All right, I think that how we have it is, how I've prepared it is correct. The elements of the forcible felonies are laid out as discussed previously. They're not misleading. It's one solid instruction referring to the various forcible felonies. I'm going to read it to them, and I think when they hear it from me, read to them, it's going to be eminently clear that these are separate forcible felonies, so I think they're ready to go. Any other objections?
No, sir.
All right, you ready to bring the jury out?
Yes.
You ready?
Yes.
Before we do that, all right, I want to speak directly to the observers that are in the audience. We are now about to begin closing arguments. This is when the attorneys are allowed to tell the jurors what they believe the evidence was, discuss how the law applies to this case, and explain to the jurors why they should vote one way or another. You will likely agree with one side and not the other. However, you are instructed not to behave in a manner that is distracting or in any way attempts to influence the jury using threats, intimidation, or sympathy. If the court determines that your behavior is distracting, you will be removed from the courtroom and prohibited from returning until closing arguments have been completed. This includes coming in and out of the courtroom during closing arguments if the court determines it is distracting to the jury. All right, I've got 9 copies without verdict forms. Just check. The ones I gave you should have the verdict forms, right?
Yes, sir. Yes.
Yours does? Okay, perfect.
And Judge, I will need this screen, so I don't know when you want to put it down.
All right, y'all can have a seat. All right, everybody have a seat. All right, before we get going, just to make sure one final time, did anybody discuss the case amongst yourselves? Did anybody do any research on people, places, things, or legal topics we've heard anything about? Or did anybody talk about the case with anybody outside of this jury? Members of the jury, both the state and the defendant have now rested their cases. I will now give you the initial jury instructions, after which the parties will give their closing arguments, if they wish, and then I will give you the final jury instructions before you retire to deliberate. The courtroom deputy will now hand out a copy of the jury instructions for each of you to review as I read them. The jury instructions are like your notes. You may write on them. After the trial, the deputy will collect your notes and jury instructions and return them to me to be destroyed. No one will ever read your notes. I will also add that I am confident that you can all read a lot faster than I can speak these jury instructions. Sometimes I've said to Miss Sarah that I'll take that as a challenge, but we want a good, clean record. So I am going to ask also that you stay with me as I read the jury instructions. There's also a point, like I said, where I'm going to stop, turn it over to the attorneys to do their closing arguments. So it's just be better if we all stay together. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Ashley Benefield, the defendant in this case, has been accused of the crime of murder in the second degree. Ashley Benefield is accused of murder in the second degree. Murder in the second degree includes the lesser crime of manslaughter, which is unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Douglas Benefield was killed by Ashley Benefield, you will then consider the circumstances surrounding the killing in deciding if the killing was murder in the second degree or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1. When the killing is committed by accident and misfortune, and in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion, upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Ashley Benefield may be found guilty of murder in the second degree or any lesser included crime. To prove the crime of murder in the second degree, the state must prove the following three elements beyond a reasonable doubt. 1. Douglas Benefield is dead. 2. The death was caused by the criminal act of Ashley Benefield. 3. There was an unlawful killing of Douglas Benefield by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2. Is done from ill will, hatred, spite, or an evil intent, and 3. Is of such a nature that the act itself indicates an indifference to human life. In order to convict of murder in the second degree, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Ashley Benefield did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person. And B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And C, there was not a reasonable amount of time for a reasonable person to cool off. And D, a reasonable person would not have cooled off before committing the act that caused death. And E, Ashley Benefield was, in fact, so provoked and did not cool off before she committed the act that caused the death of Douglas Benefield. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, you should not find her guilty of murder in the second degree. If you find that Ashley Benefield committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she discharged a firearm, and in doing so caused the death of Douglas Benefield, you should find the defendant guilty of murder in the second degree with discharge of a firearm causing death. If you find that Ashley Benefield committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she discharged a firearm, you should find the defendant guilty of murder in the second degree with discharge of a firearm. If you find that Ashley Benefield committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she actually possessed a firearm, you should find the defendant guilty of murder in the second degree with actual possession of a firearm. A firearm is legally defined as any weapon which is designed to, or may readily be converted to expel a projectile by the action of an explosive. To actually possess a firearm means that the defendant A, carried a firearm on her person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crime indicated in the definition of murder in the second degree is manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. Douglas Benefield is dead. 2. Ashley Benefield intentionally committed an act or acts that caused the death of Douglas Benefield. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to do harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Ashley Benefield committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime she personally used a firearm, you should find her guilty of manslaughter with a firearm. A firearm is defined as any weapon which is designed to, or may readily be converted to expel a projectile by the action of an explosive. If you find that Ashley Benefield committed manslaughter, but you are not convinced beyond a reasonable doubt that she personally carried, displayed, or used a firearm, then you should find her guilty only of manslaughter. It is a defense to the crime of murder in the second degree, including manslaughter, if the actions of Ashley Benefield constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Ashley Benefield does not have the burden of proving that she was justified in using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using deadly force. The law on justifiable use of deadly force is as follows. If Ashley Benefield was in a dwelling in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent A, the imminent death or great bodily harm to herself, or B, the imminent commission of burglary, false imprisonment, or aggravated assault against herself. The elements of the forcible felony of burglary are: 1. Douglas Benefield had permission or consent to enter a structure owned by or in the possession of Ashley Benefield. 2. Douglas Benefield, after entering the structure, remained therein, A, after permission to remain had been withdrawn, and with the intent to commit an offense other than burglary or trespass inside the structure, or B, to attempt to commit a forcible felony. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Even if an unlawful remaining in a structure is proved, if the evidence does not establish that it was done with the intent to commit an offense other than burglary or trespass, then a burglary has not occurred. Structure means any building of any kind, either temporary or permanent, that has a roof over it and the enclosed space of ground and outbuildings immediately surrounding that structure. The elements for the forcible felony of false imprisonment are: 1. Douglas Benefield forcibly or by threat confined or restrained Ashley Benefield against her will. 2. Douglas Benefield had no lawful authority to do so. The elements of the forcible felony of aggravated assault are: 1. Douglas Benefield intentionally and unlawfully threatened, either by word or act, to do violence to Ashley Benefield. 2. At the time, Douglas Benefield appeared to have the ability to carry out the threat. 3. The act of Douglas Benefield created in the mind of Ashley Benefield a well-founded fear that the violence was about to take place. 4. The assault was made with a fully formed, conscious intent to commit false imprisonment upon Ashley Benefield. The elements of false imprisonment are as I have previously explained to you. If the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then Ashley Benefield may be found to have been in fear, and actual fear on the part of Ashley Benefield need not be shown. In deciding whether Ashley Benefield was justified in the use of deadly force, you must consider the circumstances at the time the force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. If you find that Ashley Benefield, who because of prior threats or difficulties with Douglas Benefield, had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Douglas Benefield, you may consider this fact in determining whether the actions of Ashley Benefield were those of a reasonable person. If you find that at the time of the alleged murder in the second degree, Ashley Benefield knew that Douglas Benefield had committed acts of violence, you may consider this fact in determining whether Ashley Benefield reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Ashley Benefield and Douglas Benefield. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whatever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, the conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's question? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and the other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony they gave in court? Whether the state has met its burden of proof does not depend on the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give their opinion. However, an expert opinion is only reliable when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of all of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Now, at that point, if you would please mark that spot, that's where I'm going to ask you to stop. And I'm going to take a brief moment and explain the verdict form to you. The attorneys will now be given the opportunity to do their closing arguments if they wish. Sometimes they'll show the verdict form to you, so I want to take a minute to explain it and how it works. So, and I know you can't read it from there, and you do not have a verdict form in your packet. I have the verdict form that I'll be giving you. In the Circuit Court of the 12th Judicial Circuit in and for Manatee County, Florida, State of Florida versus Ashley Benefield, case number 2020 CF 3014AX. Verdict. We, the jury, find as follows as to the defendant in this case. Check only one. When it says that, it means as to A, B, C. So as a jury, you will deliberate, and you must agree on either A, B, or C. A, the defendant is guilty of murder in the second degree as charged. B, the defendant is guilty of manslaughter, a lesser included offense. C, the defendant is not guilty. And what I meant to say earlier is you must agree unanimously. That is, all of you must agree on what the verdict is. Now, if you, as a group, you debate, deliberate, and as a whole, you find either A or B, then you must go down here to this series of questions. If you find the defendant guilty of A or B above, then you must answer all of the following questions. 1, did Ashley Benefield actually carry a firearm? Yes, no. 2, did Ashley Benefield discharge a firearm? Yes, no. 3, did Ashley Benefield, as a result of discharging the firearm, cause death to Douglas Benefield? Yes, no. So say we all this blank day of July 2024 at Bradenton, Manatee County, Florida, and then it'll be signed by the foreperson, and the foreperson will print their name. And I'll talk about that when I give you the final instructions. Members of the jury, the attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, you should listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide its time between an opening argument and a rebuttal argument after the defense has given its closing argument. State.
Can I have the screen, please?
Yes. And how much did you want to reserve?
Are you going to give a warning?
Yeah. You want the lights down?
Yes, if we could just do the ones back there. Domestic violence is absolutely a real problem. There are many, many women around that are in horrendous situations. Women, and sometimes men, that are in situations where they're being abused and beaten horribly on a regular basis. People that feel like they cannot get out, they have no way to get out. That is not this defendant, and it never was. Now, some of those women who are victims of horrible domestic violence may be justified in a situation where they have to use self-defense to kill their abuser. Absolutely, there can be situations where that might be a valid point, but not for this defendant. This defendant used domestic violence and allegations of it to make progress on her goal. And her goal was she wanted sole custody of that child at all costs. And to understand that, I think we need to go through the background, even though this case really is about what happened in that house. What happened in that house, the last moments of Doug Benefield's life. But we need to go through the timeline to see the tenor of this relationship and to see how it unfolded. The bottom line is you have to decide at the moment that she pulled the trigger in that bedroom, was it reasonable and was it necessary? That self-defense instruction, it's called justifiable use of deadly force, is very complicated. But there are two words that are very, very important: reasonable and necessary. And those are the words that you have to evaluate everything this defendant did. So let's go through the timeline. In September 7th of 2016, this couple was married. After knowing each other 13 days and a 30-year age difference, they married each other. According to the defendant's testimony, very shortly after, there starts controlling behaviors and name-calling. Then, 4/15 of 2017, Doug Benefield has a vasectomy reversal. They decided, in less than a year of marriage, they wanted to have a child. This is about the time where the defendant says that there are these angry outbursts in South Carolina by Doug Benefield. And the state is not trying to say to you that Doug Benefield was an angel. The state is not trying to say that his behavior in South Carolina was appropriate. Not at all. His behavior was unacceptable at the time. But he also apologized for it. If you look at the the text messages between him and Ashley, he says, "I'll spend the rest of my life making this up." And he says how wrong he was and how stressed out he was. And he apologizes. But that's not the most important thing. The most important thing is what happens after that. Does any more abuse happen after that? Within days of these anger outbursts in South Carolina, there's a lavish wedding reception where everyone seems to be happy. And then within about 3 months after that, the defendant gets pregnant. In the midst of all of this, she gets pregnant. The very next month, she moves to her mother's house in Florida because she's so sick and needs someone to take care of her. That is the last moment that this defendant ever lived in the same house with Doug Benefield. Was August of 2017. Very, very important date. Within a couple of months after getting to Florida, the defendant starts this campaign of complaints against Doug Benefield, all with the idea to get sole custody of her child that she was pregnant with. So she filed for a South Carolina injunction while she's in Florida. She doesn't even live in South Carolina. She doesn't even live with the person that she's trying to get an injunction against, but finds it appropriate to get an injunction in South Carolina. It is a mutual injunction. Don't mistake that. The judge did not make any findings of fault. There was no evidence presented. No one was ever found at fault. The two parties, Doug and Ashley Benefield, agreed, fine, we just won't contact each other. That is not what we are used to probably in Florida for injunctions. Then December 2017, so that's within a month, Ashley starts the series of allegations in Florida. So she files for this injunction in South Carolina. They mutually agree, okay, we're not going to talk to each other, we're not going to be around each other. But she starts a series of complaints in Florida. She starts saying he violated the South Carolina injunction, and she claims he's poisoning me. He's poisoning me and my unborn child, and also goes back to things that he supposedly did in South Carolina when they don't even live together. So on March of 2018, she gives birth. She gives birth after Doug Benefield has a lawyer contact her, because they're not really supposed to be talking to each other. The lawyer helps him write a letter. Says, I want to be a part of this child's birth. Please, I'll honor your wishes, but please let me be a part of this child's birth. Not only does she not respond, when she goes early to give birth, she doesn't tell Doug. She doesn't tell him once the baby's born. For weeks, he didn't know this child was born. Then she does not put his name on the birth certificate. Now, alleged behavior or not, she knows who the father is. Why is she not putting the father on the birth certificate? And then she gives this child her maiden name instead of her father's maiden name. Or, I'm sorry, her father's last name. Then 1 month later, she starts complaints to law enforcement. She says he violated the injunction in South Carolina. She files for a new injunction in Florida based on all of the same things in South Carolina. This is all based on the same information that she had already spoken about in South Carolina. And when she went to law enforcement trying to get them to file criminal charges against him for violation of an injunction, law enforcement was not on her side. And you heard from Detective Gillum about the conversations that they had. And the conversations that she had with Detective Gillum are the entire crux of this case. It is her motive, it is her plan, it is what she did everything for. He said her true motives were to use the criminal system to affect her family court case to get sole custody of her child, which is what she wanted from the very beginning. He said it was very clear that she was trying to use the criminal system in that way, and he was very uncomfortable with that. He had forwarded charges to the state attorney's office, let the state attorney's office decide, which they end up not filing, by the way. And she did not think that was good enough. She was furious. She said, and I quote, "If the judge sees him arrested, it will help me keep my baby." She wanted him arrested in family court in front of the judge and made that very, very clear. That was what was important to her. The detective said in 20 whatever years that he's been doing this job, he has never had anybody ask him to do that. Never. And she was very adamant, and they talked for 15 to 20 minutes. And she went from crying almost hysterically to aggressive and yelling at him and then screeching at the top of her lungs, all because she could not get him to go with her plan. She also said to him, "You will fucking arrest him in front of the judge, and I will make sure that you do." Then she said, "I will do anything I have to do to keep my baby, asshole." She wasn't saying, "I'm so afraid of this man. Please help me. I'm a victim of domestic violence. I need help." Not at all. She's saying, "I want to keep my baby." And she's afraid that this man, who is 30 years older than she is, and a lot more established, has a lot more money, has a lot more resources, she's afraid that this man is going to get custody of her child instead of her. So after this discussion with Detective Gillum, in about September 17th of 2018, the second hearing for the injunction happens. Remember, this injunction hearing was in two parts. One was in July and one was in September. All of the same allegations. He's poisoning me, the stuff in South Carolina. Again, they're not even living together. And she fails. The judge in that case says, no. No injunction. And this man will have immediate visitation with his child, who, by the way, was 6 months old and he'd never met her. It wasn't for lack of trying. There may be a lot of deadbeat dads out there that don't care about seeing their children and don't want to be around. This man tried everything to be around for his child, to be there for the birth, to visit the child, to see the child, and she kept the child away from him for 6 months. And the first visitation, you heard from Stephanie Murphy, the first visitation, all of a sudden, everything's glorious again. Now, all of a sudden, the defendant wants to go with him. I'll go with you. And now, we're in a stage where we're acting like we're going to get back together. Because she knew the court system was not working, and she was afraid that if she didn't buddy up to him, he was going to get this child away from her. So it begins the charade of her telling him, we're going to get back together, we're going to be a family. She played on Doug Benefield's wishes. He wanted more than anything to have a family, his family together, to have his wife that he loved and this child all together. And she kept telling him, yes, that's what we're going to do. That's what we're going to work towards. So that starts about a year of them kind of getting along, right? And then September of 2019, which is about a year later, Doug finds out she's dating someone else. He files for divorce. And a series of complaints start against Doug Benefield for now abusing the child. Which, by the way, were investigated by law enforcement, and not one of them resulted in any charges. And May 1st of 2020, the defendant, having failed in the criminal system, again, files for another injunction based on these allegations that fail in the criminal system. Do you see a pattern here? May 4th, only a few days later, after she files for another injunction, Doug files for sole custody of the child. This is Ashley Benefield's biggest fear, that this man is going to get sole custody. But she's making all of these grand allegations against him that he knows are not true. There's got to be something wrong, and it's probably not safe for this child to even be with her. So he files for full custody. And what happens? All of a sudden, she sidles up to him, and now we're getting back together. And we start to go to marriage counseling, and we go see Dr. Forrest, who referred them to Dr. Quintel. And they're going to marriage counseling about how they're going to get together. And to Doug, she's saying, yes, I want to reconcile. Let's get back together. But behind his back to the doctor, she's like, no way, no how. I'm not getting together with him. Then she goes on all these social outings with Doug and the child. Goes to the beach, goes to the movies, goes out to dinner, to lunch, swims at the pool at his apartment complex. Giving Doug all of these mixed signals. We're gonna reconcile. We're gonna get all this back together. And in the back of her mind, she knew all along. She was just waiting for an opportunity to strike. And then 6/1 of 2020, the system sends them for an evaluation with Dr. Broder. And they're like, what is going on here? Someone needs an evaluation. So they go to this evaluation with Dr. Broder, and this deception on the part of Ashley Benefield continues. She does the same thing. We're going to reconcile, we're going to get back together, and then when she's not with him, she's saying that that's not true. And then towards the end of September 2020, but before the 21st, there is a last meeting between Ashley Benefield and Dr. Broder. He said it was in his office. She was leaving. She was walking through the waiting room and going to the door, and she's upset because this is not going fast enough. I want the report. I want this to be done. We need to move to Maryland. Why do you think she's moving to Maryland? We need to move to Maryland. This is taking way too much time. And she says to him, I'll take matters into my own hands. And that was 7 days, up to 17 days before, depending on about what time it was, he gets murdered. On 9/21 of 2020, after this comment to Dr. Broder, she goes to mediation with Doug Benefield, and they end the mediation saying, everyone's going to drop everything. Because at this point, Doug had filed for a divorce, again. And Ashley had filed for an injunction, again. So at this hearing on the 30th, those things were going to be heard, as well as a joint motion to release a report by Dr. Broder. But they go to mediation, and at the end of mediation, it's very fast, because they all agreed, we're dropping everything. We're going to Maryland. So that was the plan. Ashley Benefield had no intention of dropping that injunction. Look at the text messages between her and Doug that were introduced by the state for the week before this homicide, murder happened. They're talking to each other about the fact that everything's going to be dropped. Give this attorney a call. Okay, I'll give that attorney a call. Ashley's telling him we're going to drop everything. And she knew that was not true. Her attorney testified, we were not dropping that injunction. We were ready to call witnesses. At that hearing on the 30th, we were going forward. Ashley Benefield knew that day it was over. It was going to be over. Her entire charade was going to be done. This entire get along, go along that she's trying to say was because of domestic violence. She was just trying to fake Doug out. And she knew that on the 30th, her ruse was up. Because if she goes forward with an injunction, what better way to tell someone you're not going to reconcile than trying to get another injunction? So what does this timeline tell us for what happened at the time of the shooting? Okay? It's background, yes. But also, it tells you they did not live together for 3 years. before the homicide. And if there was violence towards Ashley Benefield in South Carolina, that was 3 years before. And they haven't lived together since. And is that something that justified her being in such fear of Doug Benefield that it was necessary to shoot and kill him? The answer is no. I do want to talk a little bit about domestic violence, and Mr. Ferris testified a lot about this wheel, this power and control wheel. So I want to put it up there. First of all, the overarching umbrella right here is physical and sexual violence. There is no physical violence in this case. There is no sexual violence. There's no allegations of any of this, unless you believe the defendant that the day this happened. But there was never any allegations of physical or sexual abuse. However, it's a power and control wheel. So let's go over some of these things. One of the first categories, using intimidation. So this is, did Doug Benefield use intimidation to control Ashley Benefield? They hadn't been together in 3 years. The first year they were apart, they barely even saw each other or spoke. So how exactly was he using intimidation to control her? And there's no allegations of threats during this time. The defendant testified she didn't say that there was anything going on during this time. One of the other prongs is using emotional abuse. Same answer. They weren't together. There was no allegation of emotional abuse. The defendant didn't talk about anything that was going on during this 3-year period that he was emotionally abusing her. She felt comfortable enough. She even said, I told him when he thought he was going to move in with me, I told him I didn't want to do that. She felt comfortable enough to say, no, you're not moving in with me. But yet somehow he's emotionally abusing her. Then using isolation. How can that even apply when they're not even together? He has no influence over her comings and goings, over her daily routine, and she even started a new relationship with someone else. So how is it that Doug Benefield is exercising control over her by using isolation? And then minimizing, denying, and blaming. Well, nothing had happened in 3 years. So was there even anything to minimize, deny, or blame? Nothing had happened. And there was no evidence of anything happening other than maybe some things that the defendant said happened, but did they really? For instance, Doug Benefield's peeking into my windows. My neighbor told me that Doug Benefield was peeking in my window. Okay, let's think about this. She said it was her across the street neighbor. Okay? So these houses face each other. Their backyards are behind the houses. The neighbor said, I saw somebody walking in my backyard that had a ball cap on. It was dark. I couldn't see what he looked like. And when I asked him what was going on, why was he there, he said he lived there. And somehow this translates to this person is looking into your windows across the street, and the neighbor couldn't identify who it was. And here comes Ashley with her recording. Here, let me play this. Did you recognize his voice? Does that sound like him? Okay, it was Doug. Doug was peeking in my window. Really. Then the next spoke on the wheel is using children. This man did nothing but try to see his child over and over and over. Ashley Benefield kept his child from him. So if anybody was using power and control, it was Ashley Benefield against him. And I think if you look at a lot of these spokes, you're going to see a lot of behaviors on the part of the defendant that were actually using power and control instead of being a victim of power and control. Then male privilege is the next spoke. There was absolutely no evidence of male privilege. There was an email to the realtor to get a house, just as one example. And if you read that email, he says, okay, but I have to check with Ashley first. How is that male privilege? He's telling this guy he's going to talk to his wife. Using economic abuse. Again, they didn't live together. Ashley Benefield's financially independent. She has her own home. She's completely separate, has her own car. That doesn't apply. Using coercion or threats. No threats. She didn't say there were any in those 3 years. None. There were no allegations that he threatened her or hit her or did anything. He didn't make any reports or threaten to report her to Department of Children and Families. He didn't say, oh, you better do what I say or I'm going to call DCF and tell them you're a bad mom. No. That was the other way around. That's what she was doing to him. There were no allegations that he was trying to get her to drop charges. Quite to the contrary. She was not dropping any charges of anything. And Mr. Ferris talked at the end of his testimony about domestic victim mentality. So let's talk about this. One of the things in the domestic victim mentality is covering for the abuser. Like making excuses, covering for them. Did you ever hear any evidence of the defendant doing that? Never. Making excuses for the abuser, making excuses for their behavior. Not once. She was telling everybody, anybody that would listen. Not reporting abuse, same answer. She was telling anyone that would listen and a bunch of people that wouldn't listen. Dropping criminal charges. That certainly didn't happen. The domestic victim mentality, she won't stand up for herself. Never saw that with this defendant. And she won't leave the relationship or the home. She left. She left the home, she left the relationship. They were not together for 3 years. So how does this domestic violence mentality, domestic victim mentality even apply to her? It doesn't apply to her. And don't be mistaken about what applies to her and what does not. Even, like I said before, even if you think that Doug Benefield's behavior was inexcusable and abusive in South Carolina, you have to remember that we are talking about 3 years later. After all of this, time has gone by and there are no allegations of anything else in between. So I want to talk to you a little bit about the jury instructions that the judge talked to you about. I just have a few on here that I want to go through. It's got to be overwhelming, I know, when you read the packet. There's a lot of words. So I try to help break it down a little bit. So the defendant is charged with murder in the second degree. So I would recommend the way you go through this is check off the things that you don't have to argue about. If everyone agrees to one of these, just check it off. So number one, Doug Benefield is dead. That should be easy. Check it off. There's no dispute. Number two, the death was caused by a criminal act of Ashley Benefield. Check it off. She shot him. Number three, there was an unlawful killing of Doug Benefield by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. Now that's a lot of words. So what does that mean? The next slide explains what that means. An act eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, and again, check off things, okay? So a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. Shooting a gun, firing a gun into someone clearly qualifies person of ordinary judgment would know that that would kill someone. Check. Let's go to number 3. That this act is of such a nature that the act itself indicates an indifference to human life. Pulling a trigger, pointing a .45 caliber firearm at someone and pulling the trigger 4 times shows an indifference to human life. So then we go back to number 2. If the acts are done from ill will, hatred, spite, or evil intent. Now notice, this is or. It does not have to be all of those. Ill will is a pretty low threshold. What is ill will? Devising a plan to keep this man away from his child. Is that ill will? Sure. Filing complaints against him that are unfounded and nobody ever files, fictitious complaints, that's ill will. Trying to do anything she can to keep this child to herself is ill will. Everything she did was for this goal, and everything she did was to get Doug Benefield out of the way. And unfortunately, the way she did that was by killing him to get him out of the way. That is ill will, hatred, spite, or evil intent. Now, the judge read to you that there's something called a lesser included offense. And what you may have heard, but it's in your packet, is the way you should handle a lesser included offense is such. So if you agree as a jury that the state has proven a charge beyond a reasonable doubt, you should start with the highest charge. So start with second-degree murder, and if all of the jurors agree unanimously that it's beyond a reasonable doubt that the state has proven their case and the defendant is not entitled to self-defense, then you don't even get to manslaughter. You don't have to go and then review manslaughter. You stop at the highest charge. You only get to manslaughter if you don't agree on the top charge. Then you get to the description of manslaughter. And again, check off the things that you are not arguing about. Doug Benefield is dead, check. Ashley Benefield intentionally committed an act or acts that caused the death of Doug Benefield. Yes. There's no question as to that. Now, the state did prove this, but the state also proved the added element of ill will, hatred, spite, or evil intent. So we have proven manslaughter, but we have also proven above manslaughter. And I want to show you the verdict form, and then we'll go back. This was the verdict form that the judge showed you, just to let you see it ahead of time. And this is the heading that the judge read. We, the jury, find as follows. As to the defendant, in this case, check only one. And here's A, B, and C that the judge talked to you about. Defendant is guilty of murder in the second degree as charged. Defendant is guilty of manslaughter, a lesser included offense, or defendant is not guilty. And then if you find A or B, then you have to answer all 3 of these questions. And then the foreperson will sign it and print their name. So the real question in this case is, was there self-defense? Was there justifiable self-defense? And the self-defense instruction is long, and you'll have it to review in the back. However, what you will notice are 2 words that come up all the time in that instruction. Self-defense, justifiable use of deadly force, would be Ashley Benefield was justified in using deadly force if she reasonably believed such force was necessary to prevent imminent death or great bodily harm or a forcible felony. You're going to see those 2 words. And like I told you a little bit earlier, that's what you need to think of each time that you're trying to evaluate whether she used force appropriately. So let's get to the date of the offense, okay? Clearly, these 2 are getting along. at least according to Doug Benefield, he thought they were getting along. If you look at the text messages between the two of them, if you go by the information that you had from the witness stand that Ashley was acting nice, she was acting like they were going to try and reconcile in Maryland. They were moving together. They were using the same truck. He was coming to her house to help her move the heavy things. So they were getting along. They actually went to the mediation during this time. It was about 3 days before she killed him. They had mediation where they said they were going to drop everything, move into Maryland, everything's going to be fine. But obviously that was not Ashley Benefield's plan because she knew she wasn't going to drop the injunction. Obviously, the day of the offense, Doug Benefield had a right to be at the house. She invited him over. They had text messages back and forth. Trucker on the way, you know, he's taking a picture of the stuff in the back of his truck. And she'd let him in the gate numerous times before. So he had a right to be at the house. She clearly was not afraid, but she had him over. And then her mother clearly was not afraid for her because then as soon as he gets there, she goes to the park with the daughter. So nobody's afraid at this point for Ashley Benefield's safety. And there's only one person who knows what happened in that house that is still alive. And that's Ashley Benefield. And you heard her story. And she made herself a witness just like any other witness in this trial. And you will judge her credibility and the truth of what she said just like you do any other witness. And see if it matches the evidence in this case. If you noticed, when being asked questions, she became evasive. If questions got a little too difficult or she didn't really have an answer for it, specifically on cross-examination, she would use methods to avoid answering the question. One of the methods that you saw over and over was, I don't know, I just don't know, I don't know. The other method was crying. Started crying. Did you ever see one tear come out of her eyes? Did you ever see one drop of liquid? One red eye? One swollen eye? She had a breakdown. We had to take a break. Crying hysterically. Takes the stand right after that. Eyes are just fine, makeup's just fine. That goes to her credibility. What is she trying to convey to you? The truth or her version of events? Let's look at what she did say. She said, during this move that Doug bumps her on the shoulder a couple times, body check or something. She didn't really act that out very well. Who knows what that was. Doug, carrying a box, rammed a box into her stomach and scratched her. But did you see those pictures? Does that scratch look like a scratch from a cardboard box? Wouldn't you expect a bruise to be there as well? You'll have the pictures in the back. So look at those pictures and see. There's no bruising. They look like cat scratches. The defendant also said when they were by the front door to the house that he grabbed her by the wrist and hit her in the head. So when I asked her, okay, what do you mean hit? Well, I don't know. Okay, was it an open hand? Was it a closed hand? What was it? I don't know. She should know if a grown man balled up his fist and punched her in the side of the head. And there would be a lot more damage than what she claimed she had. But she didn't know. He just hit her. Now, 4 people testified that they saw her after this incident, very shortly after this incident. Well, one of them was 3 days later, but the rest of them were very shortly after this incident. John Sands, the neighbor, he didn't see any swelling. He didn't see any injuries. He didn't see any disheveled clothes like there'd been a, rumble. Detective or Officer Burrell, Deputy Burrell, was the one that put her in the back of his squad car. No injuries. Didn't notice any injuries to her head or swelling to her face. Crime scene tech Dvorak took pictures. Didn't notice any injuries, any swelling to the face. 3 days later, crime scene tech Conlon takes pictures just to make sure, because bruises don't always come up right away, that she's not bruised. No bruises, no swelling, no nothing. But yet the defendant sits right here and tries to tell you that her eye was droopy and the side over here was swollen. Let's look at these pictures. These are 4 pictures that were entered into evidence. The first picture was, the defendant said, was before she even knew Doug Benefield. She thought it was before she even knew him. The second picture at the top, over on the right, is the night of the shooting. Down lower left is 3 days later. And then one over is about 5-6 weeks later. Does it really look like her face is swollen? She said the side. She said right here. On the right side. Or, I'm sorry, the left side. Right here. The left side of her face doesn't, it actually looks slimmer than it did in the picture taken before she even knew Doug. So let's talk about what she did when she claims that Doug grabbed, I think she said she was going for the front door, he grabbed her arm, she kind of spun around, he hits her in the head, although she didn't know if it was open hand or not, and then she said, I just wanted to get away. I just wanted to get away, right? Here's the front door, right? She went this way and could have gone right out the door. But she just wanted to get away. She didn't go right out the door. She turned to her right and went into this room. This room that has nothing in it except for a mattress, a broom, and a hamper, and 2 handguns. It's hard to see in this picture because of the lighting, but I just want to remind everyone, here's the mattress, here's the broom, nothing else in this room, but there's a hamper right here with a gun on it, and there's a gun in this closet right here. And that's where she runs. And this is a better picture of the hamper and where the murder weapon was. So she just wants to get away, but she runs into the very back corner of this room and grabs a firearm. Now, she claims that as she's retrieving this firearm, he slams the door open and she turns around, right? And she sees him standing there. When I asked her to get down and show me what he was doing, that was another one of those evasive talk. I don't know, he was in a fighter stance. I don't know what fighters do, but I know it's a fighter stance. Okay, well, show me. What do you mean a fighter stance? I don't know, kind of like this. Okay, well, what are his hands doing? Just kind of moving around. Okay, so his hands are kind of moving around, and it didn't look a lot like a fighter stance. And then she said, I'm standing there with the gun pointed at him, and he lunges at me. He lunges at me. Let's think about this. So if she's standing in the room, she has the gun in her hand, and he just came in the door, and she's pointing the gun at him. She says he takes a fighting stance. First of all, he's right-handed. Do this yourselves when you get in the back. If someone told you to get in a fighting stance, what would you do? And determine for yourselves, use your common sense, which side would be bladed away? I think you'll find that your strong hand is going to be the one that's bladed away. So if he's right-handed, he's in a fighting stance, he's going to be like this. Interesting, because he's shot from this side. So he's like this, and then she says he lunges at me, right? So if he lunges at her, he's head on, straight on to her, lunging. That bullet hole would have been here and out here. Would have gone straight through him, front to back. That is not the way that bullet went. That bullet went side to side. And if he's in a fighting stance and he's right-handed, why would he have this side towards her? And Mr. Haig, the expert, the firearms expert, displayed when I said, okay, I'm going to point a gun at you. You show me where your body would have to be in order to get that trajectory. And he turned sideways. So his body in his fighting stance would have to be completely sideways. And what, he's skipping to her to lunge? I mean, how is that trajectory going to happen based on what she said? More than likely, the hands that were up was a defensive stance. He probably came into the room and said, whoa, she's got a gun, and started to turn around. He had his hands up like, whoa, what are you doing? It makes no sense to be in a fighting stance. So I want to talk a little bit about this trajectory just because there's sort of some misconception that this shot was front to back. That is just the planes with which the medical examiner uses. So it can be a little confusing. But if you look at the way this arrow is, the bullet goes in right by the right nipple and then lands right here. So it is side to side. Now, once it went in where the nipple is, did it curve a little bit to the back? Yes. That's why it's like in the back. That's why they say front to back. So it went side to side and a little bit to the back. There is no way he was facing her when she shot him. No way. Here's another angle. This is from the back. So if it went in on the side, the right-hand side, and that red dot is where it landed in the back. And let's talk about the leg wound. It's very hard to determine exactly how this leg wound happened. And we may never know exactly how it happened. But this is the basic trajectory of it if a person were in a normal standard anatomic position. This is the medical examiners said that. This is a standard anatomical position. So in a standard anatomical position, that is the way the wound path went through his leg. So you can figure out for yourself different ways that might have happened. Now, Dr. Liu said, based on information that she got from Ashley Benefield, by the way, that it must have happened this way. That once he shot the first time, somehow he falls and his legs go way up in the air and he shot like this. Where did that bullet go? If he was shot like that? The expert testified about the two that went into the wall had not gone through a body. He said the one that hit the leg was in the room. Might have been kicked, and that's normal when you have emergency technicians in there and they're kicking things around. But the projectile was in the room. It was not in the wall. So if he's falling back this way and his legs flipping way up, and by the way, Dr. Vega said the only way your legs flip up like that is if you're falling over a rail or, falling over something and your legs come up that high. So that just does not make sense with the rest of the evidence. Now, this may not be the way it happened, but it is also another way that it could have happened. He is turned away, leg up. And that bullet could have gone in and come out his knee. that his leg was bent. So you use your own judgment and decide what you think about that leg wound. What's important is this wound. This was the wound that killed him, and he was not facing her at the time. The defendant trying to say he was in a fighting stance, he lunged at me, that is just her, once again, trying to manipulate the system. She's trying to manipulate you to believe that this was necessary, he was coming at me, but the physical evidence does not bear that out. It does not show that he was coming at her and that she had to shoot him. And afterwards, she runs over to the neighbor's house. Not once do you hear her say, get an ambulance, I don't know if he's still alive. You know, I had to do it, but somebody help him. Not once. Not once did you ever hear any concern that I just shot another human being, regardless of what the facts are. No. And then she sees her mother come by the car. Not once does she say, Mom, he just came at me. Like, I had to shoot him. It was awful. Nope. Not a word. She goes back to her mom that night. Not a word. Really? You're not going to tell your mom exactly what happened? And then this lady, Russell, Barbara Russell, that she lives with for 9 months after the shooting, never tells her what happened. Not once. Remember, the defendant sat right there and said the defendant never punched her ever. Never choked her, never kicked her, never came at her with a knife, never came at her with a club, never came at her with a bat. And she was the only person armed in that room. Doug Benefield was not armed. He had no weapons. He was laying on the floor dying. And she goes to the neighbor and not once asks for an ambulance. And he dies, either on the way to the hospital or in the hospital. She was the only one armed, and it was not necessary. She did not have to shoot him. It was not reasonable. She did not have to shoot him. She had an agenda, and it worked for what she wanted, and she got what she wanted. Because after she killed him, what did she get? Sole custody of the child. And that's murder. Thank you.
All right, Mr. Taylor, do you need the screen?
I do not.
I'll turn that off for you. Yes, sir, when you're ready.
Thank you. Good afternoon, ladies and gentlemen. I have a bit of a cold. I tested 3 times and it's not COVID. Don't need to be concerned. I've just listened to the state's closing argument. I have to tell you, I think there's obviously some real different perceptions of what the evidence is. I think perhaps there's even been some distortions. You all have taken, we've observed, pretty careful notes. If I say something that is not reflected in your notes or is not as you recall it, I want you to trust your own recollection. But I think if you check your notes, you will find that what I represent to you is accurate. This is and has been a fundamentally flawed prosecution. And I think we can demonstrate that through the testimony of two of the state's witnesses. The first is Stephanie Murphy. And you may recall she was the attorney who was representing Douglas Benefield. In my cross-examination of Stephanie Murphy, I served up for all of us, but especially for you, the members of the jury, what the state's theory of prosecution was. And I said, so Miss Murphy, let's be clear so that there's no misunderstandings. It's your belief and the state's theory that Ashley Benefield killed her husband because the Broder report was scheduled to be released 3 days later. She said that's correct. Check your notes. Now, the state, in their opening statement, even made it dramatic. They said to you, this report by Dr. Broder was to be released on the 30th of September, but she killed him on the 27th to avoid that. If you look at the emails that had been introduced into evidence that reflect the conversations back and forth between Stephanie Murphy, Faith Brown, Miss Benefield's family court attorney at the time, and the judicial assistant for Judge Moreland, you will read in no uncertain terms, black and white, the Broder report was not set to be released on September 30th. Not only was it not set to be released on September 30th, there was not even a day for it to be released scheduled. Stephanie Murphy was attempting to have it scheduled. The JA wrote back in no uncertain terms, Judge Moreland will not hear that. The only thing being heard on September 30th is the domestic violence injunction. The other witness that I think reflects what a fundamentally flawed prosecution this is Detective Gillum. And you might recall that Detective Gillum, check your notes, said that the South Carolina domestic violence injunction that required no contact by either one did not go into effect until November 27th. But if you look at the written email that we introduced into evidence, where Detective Gillum is contacting Gina Torsha, Miss Murphy's assistant, Detective Gillum tells her, wait a second, he's helping them. Wait a second, this injunction, unless I'm reading this wrong, this injunction went into effect on November 3rd. The judge signed the order on November 27th, but on November 3rd, he announced it in open court, and Doug was present, and so was Ashley. So unless I'm reading this wrong, I want you to be aware of that. This is Gillum trying to help them. This is the same Gillum who gives you quotes of exactly what Ashley Benefield said 2.5 years later without having one word of it written in his earlier report. The same Gillum who I asked the following questions of. Detective Gillum, do they teach you in police academy about the importance of writing reports? Sure. And is the reason why the reports are so important is because it preserves important facts about a particular incident? Yes. So how many cases do you handle, Detective Gillum, in a month? You might recall he said, well, probably about 20. And then we multiplied that out by 2.5 years. I think we were into about 600, 700 cases. Yet he remembers the exact words she had to say, despite the fact that on the day she said it, not one word of it appears in his supplement 2.5 years earlier. Ladies and gentlemen, Detective Gillum, you might also recall, countermanded the capias, the arrest warrant that the other deputy issued for Doug Benefield when Ashley went down there and explained that Doug Benefield had mailed her this package in violation of the South Carolina restraining order. Detective Gillum said he remanded it, he reversed it, and he was going to refer it over to the state attorney's office. This was a good old boy network. They liked Doug, and they never looked back. And that's the truth of the matter. Do you not find it astounding that Detective Gillum, 2.5 years later, could remember such things as Ashley Benefield saying, if the judge sees you arrest him in front of her, it'll help me keep my baby? Isn't that something that you would put in a report? I think perhaps the most disturbing thing about the testimony of Stephanie Murphy and Detective Gillum is the following. Remember that common sense I told you about that you're going to be able to take with you back into the jury room, and that without offending anybody, there would probably be more than 100 years worth of it, which there is? Does anyone believe that either side calls witnesses that they don't know what they're going to say? So how do you reconcile the state calling Murphy and Gillum knowing that they're going to testify inaccurately? Read Gillum's written email about how he misrepresented his knowledge of when that South Carolina domestic violence injunction went into effect when he testified in front of you, and read the emails between Stephanie Murphy, Faith Brown, and Judge Moreland's judicial assistant. Okay, so what happens after that testimony? I want you to remember that the state's theory of prosecution up to that point is that Ashley Benefield killed Douglas Benefield to stop the release of the Broder report because she was so afraid of what was in it. And right in front of your eyes, I've never seen it before, right in front of your eyes, the state changes their theory, and the next thing you know, their theory of prosecution is she killed him because the domestic violence injunction was scheduled 3 days later. Check your notes. See if what I'm telling you is not accurate. Both theories, honestly, are ridiculous.
Objection, Judge.
Sustained on that.
Both theories are not supported by common sense. Let's look at Broder. What exactly was it in Broder's report that Ashley Benefield was so afraid of that she killed Douglas Benefield? Check your notes, but try to think back to Broder's testimony. I think your notes will reveal that Broder never had one thing adverse to say about Ashley Benefield. In fact, the only thing that Broder had to say was that after evaluating Ashley Benefield, he found that she had no violent tendencies. She was not prone to impetuous acts. That's it. Her only concern, according to Dr. Quintel, was that she was afraid if Doug found out what she had to say about him, that he would take it out on her or on the child. Okay, let's look at the theory then when it shifts to it being the domestic violence injunction that was scheduled for the 30th of September. What kind of reason exactly is that for her to kill Doug Benefield? If that was a reason, wouldn't she have done it before? There was already a domestic violence injunction the first time. It was denied. It was not only denied, but Judge Moreland ordered shared custody of the child. Why wouldn't she have killed him then? For 4 years, Ashley Benefield did what any law-abiding citizen can be expected to do. She filed complaint after complaint after complaint, calling Doug Benefield's behavior to the attention of the authorities with no result. Over and over again. No relief. So she kills him? Really, that's quite a leap, ladies and gentlemen. You need evidence to support such an inference. You know, you can't take innuendo and wrap it up in an inference and call it a fact. You got to have evidence that supports a theory. For example, you know, in the reasonable doubt instruction I'm going to show you in a minute, but it says a reasonable doubt can arise from the evidence, from the lack of evidence, and from a conflict in the evidence. So what evidence would you need to show to support this theory that flies in the face of common sense? Well, how about somebody who comes in and testifies, yes, I heard Ashley, I overheard her say, you know what, I'd kill this SOB before I'd let him be alone with my child. Or how about this? How about downloading from Ashley's phone when she's sitting there in her most private moments, never expecting it to be revealed to the world, searching on the internet how to kill an abusive spouse. How about that? Instead, what you saw in her most private moments, 6 months before this happened, was her searching on the internet how to co-parent with an abusive spouse. Am I making this up? Check your notes. How to get along with an abusive spouse. In my opening statement, I told you 2 things. I said that at the conclusion of the case, those were the only 2 things that would be established beyond the reasonable doubt. The first one was that Doug Benefield was a very sick guy. I think there's no doubt of that. The second thing was that Ashley's action on that day, September 27th, 2020, was absolutely justified. Let's take a look briefly at Douglas Benefield's behavior. And I want you to keep in mind Bruce Ferris's testimony, who's the former cop who specialized in domestic violence ran a domestic violence department, and then was so fascinated by it, went back to school to become a licensed mental health counselor. I thought he was a pretty persuasive witness. Doug Benefield shoots a gun into the ceiling of their kitchen to intimidate Ashley to stop speaking. Now, those are easy words for me to speak. And they fall on ears and you move on to the next thing. But I want you to try to imagine how it would feel.
Objection.
Sustained.
How would one feel sitting in their kitchen, having their husband pull out a gun and actually fire it into the ceiling of their kitchen? Can you imagine the trauma of such a statement? Do you think that that's something that you forget about after 6 months, after a year? I think that's something you remember for the rest of your life. You never forget it. Throwing a loaded gun at Ashley Benefield, threatening suicide, not only to Ashley, but to his former wife, Renee. You've got a copy of her text message that she wrote to Doug, kicking her on their honeymoon and threatening suicide. So this is twice now, not only with Ashley, but with his prior wife. Punching the dog so hard that he knocked the dog unconscious. Bruce Ferris on the wheel. Now, I'm not an expert on the wheel. I don't pretend to know it anywhere near as well as apparently Miss O'Donnell does. But I can tell you with certainty that it has a provision, and Bruce Ferris elaborated on the fact that abusers tend to hurt pets because they have no empathy, and because, check your notes, they can control the victim because the victim loves the pets. So hurt the pets, you keep the victim in line. You get compliance, control, and compliance. That's what they seek. Threw the cat down the stairs. Put a tracker on her car. The neighbor catches him in the yard at night. It wasn't in the house across the street. You've got the schematic of the houses in the neighborhood. You see Mr. Sand's house is right next door, literally, to the left of Ashley's house. Ashley's house has got the red dot on it. Cursing, yelling, screaming, belittling. Text messages, I'm in a murderous mood. I want to rid the earth of them. Take them out. That was about two guys having a conversation while Ashley was on a cruise. Doug Benefield was so demented that just hearing in the background two men speaking while Ashley was on a cruise makes him say he wants to take them out, rid the earth of them. That puts him in a murderous mood. Of course, Ashley at the time at 24 thinks, well, gee, that's kind of flattering. I guess this guy really loves me. Oh, that was just a little tip of the hat to what was to come. The South Carolina injunction, he violated it. There's no way around that. How about driving from South Carolina to Florida so that you could follow Ashley in the car? I mean, if that's not determination, what is? If that's not fixation, what is? If that's not obsession, what is? And most chilling, I thought, was Mr. Vincicaro, the realtor, who, while the injunction is in effect, from South Carolina. Look at the email between Doug Benefield and Vince Visicaro. I asked him, did you have any dealings with Douglas Benefield? Yes, I did. What was it? He was a customer looking to buy a home. Where was that home? It was the house immediately behind Ashley Benefield's house. This is sick, ladies and gentlemen. This is while the domestic violence injunction is in effect. Not only that, but then he says to Mr. Vincicaro, well, I have to first check with Ashley. Well, you know that's a lie. He can't check with Ashley because the injunction doesn't allow him to communicate with Ashley. So what's the basis for that conclusion that Doug was that disturbed? Well, how about Doug's own admissions? You have the text messages where he admits to Ashley, you know, I'm sorry, I apologize. And according to Miss O'Donnell, well, that should be the end of it. You apologized, it's over. Unfortunately, Bruce Ferris explained to you that that's the MO of an abuser. Oh, baby, I'm so sorry. Please forgive me. It'll never happen again. And it happens again. Time and time and time again. That's their pattern of behavior. And Bruce Ferris told you that. He explained that to you. Ashley Benefield got on the stand and told you about all of that. And I have a great discrepancy. I'm wondering if we were at the same trial between Miss O'Donnell's evaluation of Ashley's testimony and ours. But how about this, in addition, as a basis to establish how disturbed Doug was? How about the letter that Ashley Benefield leaves for Doug on November 17th?
Objection, not entered in evidence.
Sustained.
Judge, I was testified to by Ms. Benefield. I'm just speaking to the letter, not quoting from the letter itself.
Okay.
So she told you that she left him a letter. She told you what she put in that letter. That letter recounted some of the things that he did. Some of the things that you heard about in the trial, such as shooting the gun, punching the dog.
Objection, content of the letter.
Oh,
So, how about that as a basis to support it? She described them as controlling and manipulative. You're putting me and my unborn child in danger by the way you drive. You drive crazy when you get angry. How about Dr. Quintel? He doesn't even have a dog in this fight. He's got absolutely no reason to shade his testimony one way or the other. What did he tell you that he concluded about Doug? That he was, quote, super controlling, unquote. That he was jealous. That he was intimidating. That he was a real alpha male. Dr. Quintel's description, not mine, ladies and gentlemen. And then we have Ashley, who's the victim of domestic violence. We have the history of the prior acts of domestic violence by Doug. According to Dr. Broder, the state's witness, and Bruce Ferris, our witness, victims of domestic violence look for appeasement. Dr. Broder, I even asked him, I think that word appeasement appears in your report about at least 4 times. They go along to get along. They walk on eggshells. always afraid that something they might say will set them off. And according to Bruce Ferris, what the abuser wants is compliance. That dynamic changes very significantly once a child is introduced into it. And why is that? Because the abused woman is going to look to protect her child. That's what mommies do. So she will put herself in danger in order to stand between the abuser and her child. Yet, Miss O'Donnell argues, well, when they first exchanged custody, as Stephanie Murphy said, Ashley looked happy and very content. Well, we know from Bruce Ferris that that's the compliance mode. That's what you do to protect your child. She knew how Doug was. He went off on her. The only thing worse than that would be him going off on Emerson, the child. You keep the beast at bay. Those were the words of Broder and of Bruce Ferris. Importantly, Bruce Ferris told you that victims of domestic violence appear to act happy. So you have these text messages in the week leading up to the shooting where they're saying nice things to one another with emojis and smiley faces. And you have the video of the restaurant where Ashley and her mother and Emerson are present, and Ashley appears to be acting happy, when in fact she's actually quite scared, according to Bruce Ferris. But you go along to get along. You might recall in the voir dire, I asked you about the presumption of innocence and how many of you had ever seen a cop car on the side of the road with somebody sitting in the back, and the first thing you thought to yourself was, gee, I wonder what they did to cause them to be in the back of the squad car. And I told you that the issue to be resolved in this case was going to be, was the force used justified? All of you pledged that if the state failed to prove their case beyond a reasonable doubt, your verdict would be not guilty. All of you took an oath that said, at the end of the case, if you were unsure, if you did not know what happened, if you did not have an abiding conviction of guilt, you'd vote not guilty. I want to show you the beyond a reasonable doubt instruction. Deputy, if I could have the easel, please. This is in your packet of instructions. You're not going to have to memorize it. I want to just go over it, though, for a moment. I think we can agree it's pretty important. It reminds you that the state has the obligation and the burden to prove the case, to overcome the evidence to the exclusion of and beyond a reasonable doubt. And here's how they define reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, goes back and forth, gee, I don't know, I'm not sure, then the charge is not proved beyond every reasonable doubt, and you must, not you can, ladies and gentlemen, not you may, you must find the defendant not guilty because the doubt is reasonable. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. Thank you, Deputy. Let's take a brief look at the facts rather than theories. Because once again, the prosecution could not have been more clear. Ashley killed Doug to prevent release of the Broder report. So, where was the evidence to support that theory? You can't simply say it and make it so. Miss O'Donnell comes up, and the evidence that she presents to you to support that theory is that Ashley said, I'll take matters into my own hands. Ladies and gentlemen, Dr. Broder testified that Ashley made that statement on her way out of his waiting room. And I asked him specifically about it. Please check your notes. What was she referring to? And he said, going to the authorities in Maryland to seek relief from them because the system here had failed her, and she was very frustrated. Miss O'Donnell also told you that Doug Benefield filed for sole custody of Ashley. Please check your notes. No one ever testified to that. There's absolutely no evidence in this case that such a thing was done or a statement was made. Other evidence in the case? Justin Warren, the lead homicide detective. State never even called him.
Objection.
We called him. What did he tell you? He told you that in his arrest warrant, he said it did not appear that Douglas Benefield was facing Ashley Benefield when shot. Now look, Dr. Vega came in here and testified that the shooting in the chest, the shot to the chest, was from front to back. Yet Miss O'Donnell comes up here and distorts that and tries to tell you that it wasn't from front to back. It was from side to side. Dr. Vega told you the trajectory of the chest shot was front to back, right to left. Now, not only did Dr. Vega tell you that, Michael Haig told you that, front to back. Dr. Liu told you that, front to back. There has never been any evidence introduced in this trial that the chest shot or the arm was anything other than front to back. Detective Warren told you he did not speak with the medical examiner before he submitted his arrest warrant. I showed him his report to refresh his recollection. Oh, yes, I did speak to the medical examiner. And finally, I asked Detective Warren about a supplemental report that he wrote where there's a section that provides for any bias that he was aware of that Ashley would have had against Doug. And the form was written none. And I asked, is that not where you would write in things like ill will, hate, or spite? Mike Haig, let's look at his testimony for a minute. I think you'll remember him. What he said, I thought, really presented it well, was in explaining what forensic meant. He said it's the juncture where law meets physical science. Okay? So he told you there were 4 shots. He gave you a 3-dimensional diagram, and it showed you the room and how the shooting took place and where the shots went. One shot, according to Michael Haig, went out the door and down the hallway and lodged in a book. He described it as a miss. One shot was in the wall. Told you it was a nice round hole in the wall. They put a trajectory rod in it. One shot was in Mr. Benefield's chest. It was lodged in his back. Dr. Vega removed it. And one shot was in the leg. The state's own witness, crime scene people, told you that the shot to the leg was on the floor in the room and that a piece of it had broken off, and Haig told you that as well. According to Miss O'Donnell, if you completely suspend the explanation that Dr. Liu gave you about the shot to the leg, if Douglas Benefield was running away, that's how you could get the shot in the leg. You might remember that the trajectory or the wound path to the leg was up. Ashley would have had to have been lying on the floor to shoot up so that the bullet would go in a calf. Dr. Liu explained to you exactly how that happened. We even had our summer law clerk, William Galvano, come here and demonstrate it.
It's a proper argument.
What else did Michael Haig tell you that was significant? He told you that they were moving. He said both Douglas Benefield and Ashley Benefield was moving. And he even showed you how it went from right to left in that 3-dimensional diagram, with the first shot out the door, the second shot in the wall, or one shot out the door, one shot in the wall, one in the chest and one in the leg. He showed you the 2 different cones. That would be consistent with what Ashley told you about trying to get more distance to move away from him. There was only one way to go in that room. She was already back to the back of the room, so the only way she could go was sideways, to her left. Finally, he also told you that Ashley's explanation was absolutely consistent with the physical evidence. Then we had Dr. Liu, Emma Liu, former medical examiner for Miami-Dade County, who has always testified for the state. Except here, she came in and testified for the defense. Why do you think that is? Dr. Liu told you that the abrasion to the arm, she believes, was from front to back, and she believed it was the shot that went out the door and down the hall. And the bullet would not have mushroomed or expanded, as you heard Michael Haig explain, that bullets are designed to be able to expand. Because the wound was so superficial, there would not have been enough tissue in the hollow point of the bullet to expand it. She also told you it would be consistent with Doug lunging at Ashley Benefield. And she showed you with rods how the abrasion to the arm would take place, as well as the shot to the chest. Now here's something interesting that maybe everybody's forgotten. Miss O'Donnell did not address. Who was it that told us that Doug was skilled in martial arts and trained to take the weapon away? Why, that was his daughter, Eva. So here's Doug, who gets into his fighting martial arts position and lunges at her to grab the weapon, and Dr. Liu explains the abrasion shot. All four of these shots had no pattern at all. These are four random shots, no association whatsoever, indicative of somebody who's in an absolute panic firing a gun. What's more, as not only Mr. Sant told you, Mr. Haig told you, and as the state's own witness told you, if you don't hold the weapon properly and give it the pressure that it needs, it will result in a jam from one of the cartridges, just like what happened here. So I want you to please consider something. Before evaluating the defense case, you have to first determine whether or not the state failed to prove that the shooting was unjustified. That's your first order of business. Because if the state failed to prove their allegations beyond a reasonable doubt, it's over. You don't need to evaluate the case that the defense presented. We weren't obligated to present anything, but we did. And I think we can agree that if the state's case does not meet that threshold of beyond and to the exclusion of every reasonable doubt, your verdict must be not guilty. Ashley Benefield got on the stand and endured over 2 hours of cross-examination. It was our perception that the state never landed a blow in over 2 hours. That's 2 hours in addition to the hour and a half that I had her up there on direct examination. In the world in which we live, it sounds strange to try to reduce an event like this to an explanation within an hour and a half. But this is the only form that we have to resolve things like that. So we did it. And Ashley got up there and she explained to you exactly what happened. And she did it well. And the state never touched her. Look at the crime scene photos that were taken not at some modeling presentation, not at some outing. Look at the crime scene photos that were taken by Miss Dorvac. They're in evidence, and you see if you don't see swelling and redness on those photographs. So it's September 27th, 2020, the day of the homicide. Doug arrives at Ashley's house late that afternoon, and he's already simmering. He's on a slow boil, ladies and gentlemen. Why? Because he knows she's leaving. She's leaving, he's not going with her. He's going to live somewhere else. He knows that. This was his last hope for any kind of reconciliation. And Bruce Ferris told you that the most dangerous time for a domestic violence victim is when the abuser recognizes that she's leaving. So how does Doug respond? With threats and intimidation. He would not leave. Ashley tried to de-escalate it. She could see how he was starting to build. She wanted to avoid a confrontation. Gee, you know, Doug, we pretty much got everything done. Why don't we quit for the night and we can continue tomorrow? He ignored her. Instead, his hostility starts increasing. 2 body checks where he bumps her shoulder passing her in the hall. And it's not a bump that's an accident. It's a bump to intimidate her. She told you she almost lost her balance. Then we have the cardboard box incident where he slams that into her. Once again, she tries to de-escalate it. She even apologizes to him, and I asked her, why in the world would you apologize when he was the one who hit you with the box? Well, shortly after that, Ashley's had enough. What does she do? She tries to leave. She tries to flee the house. He catches up to her, grabs her by the hand, whirls her around. His back is now at the front door, and he's got her blocked. Somehow, Ashley finds the inner strength to yell, "I'm done. You need to leave now. I'm done. You need to leave now." Please check your notes. That's going to be real important. Why? Because that revoked Doug's permission to be in Ashley's home on that afternoon. And here's what the instruction is going to tell you about that. It's in your packet. It's going to say the law and justifiable use of deadly force is as follows. If Ashley Benefield was in a dwelling in which she had a right to be, I think we can all agree this was her home. Doug did not live there. He was there by her permission on that day to help pack things. She had no duty to retreat and had the right to stand her ground and use force, including deadly force, if she reasonably believed such conduct was necessary to prevent A, imminent death or great bodily harm to herself, or B, the imminent commission of burglary, false imprisonment, or aggravated assault against herself. The elements of the forcible felony of burglary are: 1, Douglas Benefield had permission or consent to enter the dwelling or structure owned by or in possession of Ashley Benefield. 2, Douglas Benefield, after entering the structure, remained inside after permission to remain had been withdrawn, and with the intent to commit an offense other than burglary or trespass inside the structure. The offense was false imprisonment. Ashley tried to leave her home. Doug stopped her, spun her around, and held her trapped inside the house. Or B, attempt to commit a forcible felony. Forcible felony is aggravated assault. Through threats and intimidation, Doug committed the offense of aggravated assault. It's in your packet, read it. The important point is that once Ashley says, I am done, you need to leave now, he becomes, in essence, a burglar by remaining in that house after she tells him to leave. Not my words, not my law, the law that Judge White has given you. The last witness that we saw was Amy Carlton. And you might wonder how Miss Carlton fit into all of this. Well, actually, she played a very significant role. We called Amy Carlton to show that this was anything other than a staged event. If you accept Miss O'Donnell's interpretation of this, it was a staged event. It was a setup. Miss Carlton told you that she was out walking her dog with her husband. They heard a series of shots, and less than 30 seconds later, Ashley emerged from the house, hysterical, screaming, holding the gun, and ran right next door. If you're going to stage an event like this after the shooting, you're going to certainly check the scene to make sure it's going to support your version of the event. Because if it doesn't, you're on your way to prison. It's going to take you longer than less than 30 seconds to do that. The state has failed to prove anything here beyond a reasonable doubt. We prove self-defense beyond all doubt. But the burden is not ours. It's theirs. And they must prove it beyond and to the exclusion of every reasonable doubt, which, ladies and gentlemen, they just have not done. So, for the last several years, I've walked hand in hand with Ashley.
Objection.
I'm now going to surrender her fate to you. I've presented to you everything that I possibly could to show you the dynamics of what took place on that day and why they took place and what Ashley knew about Doug at the time they took place to show you that her action in using deadly force was reasonable. The judge is going to tell you in your instructions you can take into account what she knew about the domestic history with Doug, the size differential between Doug and Ashley. Ladies and gentlemen, Ashley Benefield is not guilty of murder in the second degree. She's also not guilty of manslaughter. When you read the manslaughter instruction, it tells you that it is not manslaughter if the shooting was justifiable, if it was in self-defense. The manslaughter instruction tells you that as well. You all promised in voir dire that you would stick to your guns and not be intimidated by the majority or the other jurors. Manslaughter is a compromise. Ashley's not looking for a compromise. She's entitled to more than that. This is either second-degree murder or it's not. If you follow the oath that you took and you read the instructions, we're confident you will return a verdict of not guilty in this case. Thank you very much.
Thank you, Mr. Taylor.
Thank you, Judge.
Rebuttal?
AB had enough. The defense just said that. AB had enough. She did have enough. On September 27th, 2020, she had enough. She took out a .45 caliber gun and shot Mr. Benefield 4 times. At Mr. Benefield 4 times. And why did she do that? Why had she had enough? I will do anything I have to do to keep my baby. Asshole. To a detective that she demanded arrest somebody in a courthouse because that will help her keep her baby. It is not surprising at all that Detective Gillum remembered that. That is an outrageous statement to say to a law enforcement officer. You will arrest him or I will make you. That's what she told a law enforcement officer. You think she'll tell a law enforcement officer that and she won't shoot Doug Benefield when she's had enough? No, she would and she did. Time is running out. Within a week of murdering Mr. Benefield, time is running out. She said that, I will take matters into my own hands. She said that to a psychologist who was doing reports for the state, for the court. I will take matters into my own hands. And she did, with 45. And let's talk about what we've heard, and it's my job to rebut the defense's argument. That's what I'm here for. And I think we can. And I do ask you to depend on your memory, but I want to set some groundworks. Number one, Ms. O'Donnell and I are clearly part of an old boy network. No, this is not an old boy network. This is law. This is the law. And if those law enforcement officers did not find that they had the sufficient basis to arrest Mr. Benefield, then they wouldn't have, and that's why they did it. That is not an old boy network. That is how our country works. That is what the law is for. Otherwise, any woman could walk into any police station and say, my husband did X, Y, Z, and they're just going to arrest him? No. It requires evidence. It's the same reason that law enforcement took a long time between this murder and her arrest. They were investigating it. They were making sure they had everything they needed to have. And when they did, they effectuated an arrest. And the prosecution, you heard a lot. You heard Ms. O'Donnell's name more than Ashley Benefield's name during that closing. It's not about Ms. O'Donnell. It's not about Ms. Friel. It's not about either of us. It's the state of Florida, and we have the burden. And we've overcome it. It's not a flawed prosecution. Our job is to prove to you beyond a reasonable doubt that the elements in this case occurred, that manslaughter occurred, which it did. Manslaughter is an intentional act that caused a death. She intentionally shot him, and he died. That's a manslaughter, no doubt about it. But that's not enough. She did it because she has ill will, hatred, spite, or evil intent. She had a depraved heart when she shot and killed Mr. Benefield so she could keep her baby. And does it matter if the report was coming out or if that injunction hearing was happening? No. Clearly, Miss Murphy and her client, who was murdered just a few days later, thought that Mr. Broder's report was coming out. Clearly, Faith Brown and Ashley Benefield thought or knew that they were having an injunction hearing on that day. The jig is up. She has wanted this man out of her life. She has wanted her baby to herself. And what is she doing? She's so scared of him, she has him doing her manual labor. You can come over. You can move my stuff. You can get the heavy stuff. You know what? Can you stop and buy me boxes? Can you stop and buy me tape? Do you want to go to the gardens? She told you that she couldn't dress a certain way. She was in a sports bra and shorts when he showed up. You didn't hear that he said a word. You didn't hear that he had insulted her in any way. She would have you believe all these things about Mr. Benefield. And mind you, Mr. Benefield is not on trial. Ashley Benefield's on trial. Ashley Benefield's the one that committed a criminal act on 9/27, 2020, when she murdered him. Don't be confused or distracted by emails and questions that showed you nothing. The question is, were the facts, did you learn whether or not she shot him and at the time she had a depraved heart? And there was no dishonesty by Stephanie Murphy. Don't be confused by that. I think they just had a different understanding of what was going to happen. There's certainly no dishonesty by Detective Gillum. Not remembering something, or Detective Warren, and being dishonest are two wholly different things. And nobody's expected to remember everything. The question for you, as Ms. O'Donnell said, is whether or not it was reasonable and necessary for her to kill him, for her to shoot him that day when he's in a shorts and a t-shirt and flip-flops doing her work for her. And keep in mind, this ninja we've heard of, 5'9", 169, adult small t-shirt. Adult small t-shirt, size 30 waist. We know what that means. This is not a huge man. This is not a hulking beast of a man. And the state is not contending that he didn't make mistakes. He certainly did. One of the biggest being trying to maintain this relationship. It ended in his death. But was it reasonable? Never hit her. She said he never hit her. He did some outrageous things, but never hit her in any sort, way, shape, or form. In 3 years they'd been apart. 3 years. Reasonable. Is it reasonable? She would have you believe that, and look at those text messages. Look at the text messages going into that week, that whole week. And look at, I would ask you to read the state's version, because that is the complete conversation. Oh, I'm sorry, those are the older text messages. When you look at the older text messages, this murderous intent, he's talking about her old boyfriends. She admitted that. And them choking her during sex. He's not talking about wanting to go out in the world and murder people. He's certainly not talking about her. It may not be what the average person thinks of a way to express your love, but apparently to Doug Benefield and to her, it was. Because she's like, I know, baby. Don't talk like that. She never checks him, right? She never says, oh, don't. She says, I think she says, it was just a fight. These men that were just talking, she says it's a fight. So don't be confused. Look at the evidence. But in the text messages leading up to that week, look at them. You have them. They're the ones Ms. O'Donnell did that had the video of them playing a game at Panera where they're all yucking it up. I would dispute that she was afraid. I would dispute most of what Mr. Ferris said, but we'll come back to that. So she would have you believe that this man who has never struck her, who in 3 years she reports no abuse, 3 years, he's done nothing. She left him while pregnant, did not tell him that she birthed his baby, did not give that baby his name, and then files before he ever meets his child to terminate his parental rights. And no allegations that he insulted her, came to her house and hit her, did any of those things. Shot any guns, had any guns, none of that. Right? So she did all those horrible things. If you want your baby, those are horrible. To Doug Benefield. She did all those things, and nothing happens. But this day, when she has been dictating for a week when he could come over, when he could help her, what they would do, she would have you believe that he got so enraged because she was done moving and she was tired that he hit her for the first time ever. And you get to decide if you believe her or not. I would submit to you that did not happen. There's no evidence of it, and you know it. You can see by those pictures. I don't care what Barbara Russell, who's clearly biased, right? Barbara Russell is a clearly biased witness. That's her. They have some kind of relationship that is clearly not professional. And she sat there and told you that she saw swelling. Keeping in mind, she saw her the night of. This is somebody who she had a professional relationship with and then moved in. The night of, that's who comes to her, this woman. She tells you that she has edema on her face. I don't know what edema is. I assume it's swelling and bruising. It's not there. You can see in those pictures. You're going to look at them. You can look at them till the cows come home. You won't see swelling. All those law enforcement officers who are trained to look for that, crime scene techs who went there for the sole purpose of finding injuries, and had some lawyer pointing out that her ear was red. Look at that picture. There's no redness. No redness. So he becomes so enraged that he hits her for the first time. She doesn't go down. She didn't say, I fell. This man is a trained fighter who's a ninja, and he hits her, and she doesn't go down. And she can't tell you if it was a slap or a punch. There's a big difference. There's a big difference. And if he punched her in the eye, her eye would look way different than it does. There's no swelling on the side from a punch. She'd have a black eye. Not a bruise, not a swell, nothing. So let's say it was a slap. Let's believe her. It was a slap. There's no redness, no swelling, no bruising, no scratching, no evidence in the photos. I mean, if somebody slaps somebody in the face, there's a red mark. Nothing. Within minutes. And even if you don't believe law enforcement, which I submit there's no reason to not believe them, Mr. Sand, that sweet old man who she brought this drama into his home, said, I didn't see any injuries. Wouldn't he be the one in the best position to see if she had been slapped in the face moments before? Certainly. He didn't see it because it wasn't there. It's an attempt to manipulate the system, which is exactly what she continues to do. And keep in mind, he's flipped out to the point of hitting her for the first time because she's tired and doesn't want to move anymore. That's what she told you. She didn't say she had tried to break up with him. She didn't say she had told him she didn't want to see him again. She didn't say any of those things. She told him she didn't want to live together when they were alone together, and it was fine. It was fine. So he gets so enraged and pops off and hits her or punches her in the face when she's tired, but not when she says she doesn't want to be with him. Is that reasonable? It is not. And I'm trying to think of a way to say this nicely, but I would submit to you that everything that Dr. Quintal said about Doug Benefield was basically Dr. Quintal talking with Ashley Benefield's voice. She's a manipulator. She manipulated him the same way she tried to manipulate everyone else in the world. He said he met with them 9 times, and Ashley Benefield was present for 7 of them, and alone for 5 of them. So every bit of information he got, except for 2 sessions, comes through the voice of Ashley Benefield, the way she wants him to think things are. Right? He's very controlling. He's very alpha male, which is apparently a bad thing now. He's super controlling. He's jealous. Keeping in mind, she's the one that asked Doug Benefield, are you dating her now? When he's there with her lawyer. But Doug Benefield's the one that's super jealous. And what did he tell you? Other than he thought all those things he conceded that they were all based on what Ashley told him. Not based on anything he observed. He conceded that, which I appreciate. But the weird thing was that he had this weird encounter where he thought that Doug didn't want to see the child. And what did he say? I saw him for a few minutes in my waiting room. I went into a session for an hour. And then I saw him for a few more minutes, and then we started their session. So what happened in that hour? Dr. Quintal doesn't know. For him to make any assumptions on what the relationship was between Doug Benefield and his child based on seeing him for those few minutes is not reasonable. There was no basis for that. And keep in mind, through all of that she's dictating when Doug can see that baby. We don't know if he knew she was out there. He's sitting in the lobby of a psychologist or a therapist's office. We don't know that he knew she was out here. There's so many assumptions the Dr. Quintel jumped to in order to say those things, and they're just not reasonable. Despite a court order, she's dictating when Doug sees that baby and how, and then you're supposed to believe that it was something weird about Doug that he didn't go out to the parking lot. He could have been in the parking lot for an hour for all Dr. Quintel knows. And the one thing he did say that was interesting was Ashley said she was frustrated with the system, which sounds familiar. Time is running out. I'll take things into my own hands. I'll do anything I have to do. She's frustrated because she's trying and trying and trying to do these things based on things that are not happening or not true, and it's not going her way. She tried to terminate his parental rights. Judge said, he can see that baby. That 6-month-old that he's never seen. So what did she do? Well, I don't really want him to do that, so I'm going to dictate how he sees the baby. Now I'm going to be sweet again. Now I'm going to go back. I think the only person that was in a cycle was Ashley Benefield. I'm not going to talk to you for months, but once somebody says you can have my baby, now I'm your best friend again. That's not Doug Benefield. He acted the same way in those text messages as she told you he did for 3 years. No violence, no threats, no manipulation, no emotional abuse. And that brings me to Dr. Ferris. Mr. Ferris. Mr. Ferris has never seen a relationship he wouldn't say is a domestic violence relationship. He would not concede anything. On direct, Mr. Taylor was giving him hypotheticals that had 6 or 8 aspects to them. And he was able to just answer. Oh yeah, sure, that's domestic. Goes right on the wheel. I'm asking him simple questions, and he would not concede. The only one he conceded about was that if she was living on her own, he couldn't have been economically controlling her. But how do you not concede that one, right? That's common sense. Every other thing he refused to concede. And this is one thing I will agree with Mr. Taylor. We have different perceptions because I think Dr. Ferris was clearly biased based on his inability to answer my questions when he clearly could answer the defense questions. It's clear from what was happening in this relationship that Ashley Benefield was not a victim of domestic violence. Doug Benefield's the victim in this case, not Ashley Benefield. And that there was not this power and control wheel that Doug Benefield was on. And keep in mind, Mr. Ferris would have you believe that somebody could be violent and then never be not violent again. That's what he said. I said, are you telling me that once there's violence in someone, it can never be changed? Well, if that's true, why does he teach CBIP? He makes his money on CBIP, right? Certified Battery Intervention Program. If what he told me was true, he's wasting people's time because he doesn't believe anybody can get better. And we all know that's not true. People change. People learn. People realize what they've done. People apologize for what they've done. And while saying the words is not enough, 3 years of not being in any way violent or threatening or abusive, that's an indication that Mr. Benefield was trying to change. He was trying to do anything he could to be with his wife and to be with his baby. And Mr. Taylor the defense kept saying trauma. She was so traumatized by this gunshot in the ceiling. So she had a baby with him? She testified to you that happened before they reversed, or around the same time they reversed his vasectomy. That's a big deal. That's a decision. That's not it. I think Mr. Taylor said, you found yourself pregnant. She didn't find herself pregnant. She planned to have a baby. They planned it together. They went through medical procedures to do it, and they did it. All the while, she's so traumatized. I would submit to you that is not the case. She wanted a baby, and she got one. But Doug was in the way. And as to that neighbor thing, it wasn't Mr. Sept. I don't know where that came from. There was no allegation it was ever Mr. Sept. It was some neighbor across the street. And Ms. O'Donnell told you exactly what was in evidence. Somebody across the street saw some man in her backyard wearing a baseball cap, and clearly that must be Doug Benefield looking in Ashley Benefield's windows. That's ridiculous. That's a jump you cannot make. That man could have been looking for his dog. We have no idea. There's certainly no evidence he was looking at anybody's windows, other than the defense counsel saying that. And even if he was, does not make it reasonable and necessary to shoot him. Is not a basis that would cause you to believe he's going to kill you. Going to kill you. Not a basis. I would submit to you he never was in that yard, he was never looking in the windows, but even if he was, a tracker, not a basis to believe he's going to kill you, if that even happened. The house, buying the house, I read that very differently. First of all, he wasn't trying to buy, he was trying to rent. And if you don't believe that they were talking while they had this mutual injunction, they were, I'm sure. Ms. Benefield was lying to him, telling him they're going to move to Maryland and live in separate houses, but co-parent. And she was all the while planning with her attorney to have an injunction hearing in a matter of days. It's reasonable to believe that that mutual injunction was, I'm sure, Ms. Benefield was speaking to him when it was convenient for her, when she could get something out of it. It only goes with the rest of it. This letter we've heard about, that Ms. Benefield testified to all these things, it's another effort at manipulation. We don't know when she wrote that letter. We don't know what she put in it. We don't know if any of it was true. I can write a letter and tell you that I'm the Queen of England. It doesn't make it true. And just because I say I wrote it 3 years ago doesn't mean I did. I keep saying manipulation. And the reason is because this defendant attempted to manipulate the system. It didn't work. She attempted to manipulate the experts. She kind of did, right? Because what did we hear about Dr. Liu and Mr. Haig? They talked to the defendant. She told him what she says happened, right? I don't even think she told him the same story she told you based on what they said. But what do we know? So Mr. Haig, I will submit to you, I think Mr. Haig was great. I loved it. I thought he was very interesting. I thought he shed a lot of light on how this murder occurred, right? And I would submit to you that you should believe him over Dr. Liu when it comes to trajectory. He's an expert, no doubt about it. That's what he does, all the time. Dr. Liu, the medical examiner, she seems like a well-qualified medical examiner who did testify mostly for the state because she worked for the state and is now testifying for the defense. And the defense asked you, why would she do that? She did that because she's getting paid. She's not paid to be here. That's why she's here. That's why she's saying those things. And most of them are probably very accurate. So Mr. Haig tells you there's 4 shots. We know that, right? We had 4 casings. We have 4 projectiles. One is in Mr. Benefield's chest or back. And I think there was some misunderstanding of what Ms. O'Donnell was trying to show you. What she's trying to show you is that if it was from the front, because say I'm lunging, it would go in my chest and out the back. That's not what happened. It went front to back because it hit him here and came out here. Well, that's front to back. That's not front to back like it goes in my chest and comes out my back. That's front to back because it didn't end up here, right? Or she didn't shoot him in the back, it ended up in the other side of his back. It goes across his body, destroying his lungs, destroying his spinal cord, damaging his ribs. And what did Dr. Liu say? He dropped. He dropped. I think that's important. So Mr. Haig said there's 1 bullet, right? We got 4. One is in his chest. So we know where that one is. One's in the living room wall that Mr. Haig said he believed was going down and struck the tile and then bounced up and hit the wall. He knows better than me. Seems reasonable. 3 is in the wall, number 7. Perfectly round. Typical gunshot. Nothing in its path, because what did he say? If something was in its path, it would begin to tumble. It wouldn't be that perfect hole that we picture as a gunshot in a wall or a target or anything else. And then through his leg. So which bullet hit his arm? And I think Dr. Liu might have been correct when she had that young man laying on the floor. It probably went through his leg when he was on the floor, because Ashley Benefield told you something. She said, she's shooting down. We know that's not true, right? Because his chest is way up here. His chest isn't down here. But she told you that I had stopped shooting when he fell. That's also, I think, untrue. Dr. Liu told you he would have dropped. So he's paralyzed, laying on the ground, and she continues to shoot at him. Otherwise, if you believe that she's moving from left to right to get away from him, he's dancing around dodging bullets? I mean, they would have you believe this is a very tight room. I don't know how tight it is, but you can see there's either a full or a queen-size mattress in that room, and there's plenty of other room. This is not a room closet. This is a full-size bedroom. And what else do we know? Dr. Vega said that they had to have been at least 3 feet apart. 3 feet apart. Uncontroverted. Nobody said anything different. Except for our firearms guy, who talked very fast, but said he looked chemically at the shirt and found nothing. 6 to 7 feet. 6 to 7 feet. Even if we go 3 feet, you have to keep in mind, that's from the end of the gun. She is pointing a gun at him. Here to Mr. Benefield is at least 3 feet, if not 6 to 7, when she hits him in the chest. At least 3 feet when she hits him on the leg, because Dr. Vega said there was no stippling on the leg. They're not in close combat. We keep hearing about this they are not in close combat. They're a whole grown-sized man apart, 6 feet, from the end of her gun to his body. And we know that. That's from the science. That was uncontroverted. You heard nothing to question that. You can take that one to the bank. And I would submit to you that those 2 experts, Mr. Haig was the one you should be depending on, even though he also spoke to Ms. Benefield, so clearly got one side of the story, or a made-up story. And that Dr. Liu is not the expert that Mr. Haig is on trajectory. So if you go in the back and you're curious about the trajectory, I would say you should depend on Dr. Vega's testimony about how the bullets entered the body and exited, which Dr. Liu did not contest. And as for the other bullets, you should depend on Mr. Haig, because he was clearly more suited to answer those questions. As to Detective Warren, poor Detective Warren, who gets called just to be impeached, said he had opinions. You know whose opinions don't matter in this case? But Detective Warren's. Mine don't matter, Ms. O'Donnell's don't matter, defense attorneys don't matter. It's your opinions that matter. It's when you go in the back and you listen to the facts and evidence in this case, and you decide if we've proven our case. If Detective Warren, at the time in which he made his decisions, thought that he was shot in the back, that's not wholly unreasonable. He may have been mistaken. It doesn't make his opinion invalid, but what it does, it's not relevant to your decision making, because you're depending on the facts, and you have the accurate facts.
You have 10 minutes.
Thank you, Judge. I appreciate that. And that whole bias business, Detective Warren explained what that is. That's sexual bias or racial bias. This wasn't a hate crime. This wasn't a crime because somebody hates somebody else because of their sexual orientation. That's not what this is. That's not a place to put ill will, hatred, spite, or evil intent. Ill will, hate, spite, or evil intent is not bias. It's an element of second-degree murder. It's a depraved heart. And that's what Ashley Benefield had when she murdered Doug Benefield. A few more things, and then I want to talk to you lastly about the reasonable doubt. As to Dr. Broder, I think you should take some of what Dr. Broder said to heart. His concern, her concern, was not that Doug was going to fly off at the handle. She said she was concerned she would make him look bad in front of Dr. Broder. I pretended that I'm moving to Maryland and going to co-parent because I don't want to make him look bad. This man that I would have you believe was a abusive, horrible man. They have defamed him up and down. No, she didn't say that. She didn't say, I was afraid that Doug would freak out on me. I was afraid he'd do this. No, she said, I didn't want to make him look bad. She's manipulating Dr. Broder, right? She's manipulating Doug for sure. She can't say in front of Doug, I'm not moving to Maryland, because then who's going to move her boxes, right? I can't say in front of Doug, I'm not moving to Maryland with you, because then maybe he won't drop his divorce case. Then maybe he'll try to take my baby, right? She can't let him know that. She can't let him know that till he's packed her up, ready to go. It's manipulation. And that's what she does. That's what she's done. The evidence has shown it to you. And it doesn't matter if it was the report or the injunction. She knew the jig is up. He might seek more control. It probably just went in there. But Stephanie Murphy told you that when they went, and she was trying to get an injunction, and it was denied. And he was trying to get custody, visitation, see his baby for the first time. She said something I thought was very telling. The judge gave Doug sole medical control, or primary medical control over the baby. Right? So now he's already got some control. She can't do anything without him on the medical stuff, right? Of course she's worried. Of course, because she wants that baby, and she'll do whatever she can do to keep it. Her. And I wouldn't put anything in the fact that she didn't confess on her phone, that she didn't tell somebody that that she had shot him one way or the other. She didn't even tell her mama. Her mother would have you believe that in all these years she's never said something to you. You think she's going to put it on her phone? No, she's smarter than that. If that's true, she's certainly not going to put it on her phone. And just because you search up how to co-parent with an abuser doesn't mean that person's an abuser. I would submit to you that Ashley Benefield is very smart. She's been working the system or trying for years. And if I say, oh, I'm trying to co-parent with an abuser, that looks good for me. He's an abuser. He shouldn't have my baby. He shouldn't have medical control. He certainly shouldn't have custody, partial custody, or anything else. Just because she said it doesn't mean it's true. And that's because, as I said, she tried to manipulate the system in South Carolina. It ended up being mutual. She tried to manipulate the system in Florida. She got turned down. She tried to terminate his parental rights. The judge gave him custody. She tried to manipulate the experts, as I already talked, and I think in some cases she did. And she's trying to manipulate you. You can decide what you think about her testimony. She's a witness like any other. But I would submit to you that that was all manipulation. There were no tears. You use your common sense. If you cry and have to take breaks and you're racking, then you're going to have a swollen face. Your eyes are going to be puffy. You're going to have snot. I don't know what other word to use. She didn't even get a tissue until I can't remember who, either the judge or the defense attorney told her, hey, there's tissues. Oh, yeah, I should have a tissue. She'd been crying for 15 minutes. Didn't need a tissue. That's manipulation. That's her efforts to manipulate you and make you believe that she was a victim. She is not the victim. Douglas Benefield was the victim in this case. And reasonable doubt, I would ask you to read your instructions because that board they put up was an incomplete instruction. It left out parts. And the part is that proof beyond a reasonable doubt does not mean proof beyond all doubt. You don't have to get back there and have no doubt. You have to get back there and decide, did she shoot and kill him with a depraved heart? And I would submit to you she did. And then you have to decide, was she justified in using self-defense? Was it reasonable and necessary based on what happened in that house that she shoot and kill him on September 27th, 2020? It's not a mere possible doubt, a speculative, imaginary, or forced doubt. That's not what we're talking about. We're talking about a reasonable doubt. And the state would submit to you that we have proven beyond a reasonable doubt that Doug Benefield is dead. The death was caused by a criminal act of this defendant, Ashley Benefield, and there was an unlawful killing by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. And it was not justified. It was not based on self-defense. It was not reasonable and necessary to stand 6 to 7 feet away from that man and shoot at him 4 times. And I would ask that you come back and find this defendant guilty of murder in the second degree with a firearm. Thank you. Thank you, Judge.
All right, can you go back to your instructions? And if you remember, we left off at 3.10. And we're going to ask when you find that, if you just look up at me and I'll know we're all on the same page. These are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case at all. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything that I may have said or done that made you think that I preferred one verdict over another. You may find the defendant guilty as charged, or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous, that is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. And of course, I explained it earlier. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the courtroom, in the jury room. If a juror goes to the restroom, the deliberations should cease during deliberations. These communications rules must apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you have cell phones, tablets, laptops, and other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. Let me break the script to say also, these jury instructions haven't been updated in a while, and if you have a watch, a smart watch that can communicate with the internet or make calls or send and receive texts separate and apart from your phone, that also needs to go in the Tupperware container that the deputy's holding up. All your electronic devices will be there, but you can't have anything in there that will communicate outside the jury room. If you need to communicate with me, send a note to the court deputy. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here at open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. I'm going to stop there also. When you go back, I think there was a few electronic items or things to view on a computer or on a DVD player. There's going to be what we call the tech cart that will be in the jury room with you. There's instructions on top of that about how to work the different devices and everything. If you have any problems at all, send a note to the court deputy and I'll make arrangements for our IT department to come down and get going whatever you need to get going. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. Now, as you gather up your notes and your other items, as I said, you're able to take these jury instructions, your notes, back in the jury room. Before I let you do that, though, I do want to let you know, all of you know, that in almost every case, we select the jury as well as alternate jurors in case one of the main jurors is not able to fulfill their duties. Especially as we've come out of COVID, it is not uncommon. I'd say 20 to 30% of the cases, we have somebody get sick or something happens, and an alternate juror has to step in and serve on the main jury. Alternate jurors are incredibly important, as it does happen every so often that for various reasons, jurors are not able to complete their service, and an alternate must be seated on the jury. In this case, jurors 38, 42, and 43 have served as alternate jurors. As such, I am not able to allow you to retire to deliberate with the rest of the jury. Do the 3 of you have personal effects in the jury room? You have stuff in there. Here's how this is going to work. You're going to leave your notes here. I'm going to ask you to go back in the jury room with everybody. The deputy is going to take you back. I need you to gather up all your personal effects and then come back out here to the jury, to the courtroom, so I can give you your final instructions before we let you go. but I'll need you to come back out. The other remaining 6 of you, when you go back, let those 3 jurors or alternate jurors get their things. You may not begin your deliberations until the deputy steps out, has received your electronic devices, has stepped out, and that door has closed. Then you may begin your deliberations. All right, do we have the exhibits? You've got the exhibits. Deputy, can I give you the verdict form? All right, so all of you may step out at this point, and then I'll need the 3 alternates to come right back out, please. For the other 6, you may now retire to consider your verdict. All right, you all can sit down. State defense, any objection to how the jury was charged other than the objections during the charge conferences?
None from the defendant.
No.
All right, thank you. Yes, I have the names.
Best contact number for you, that way we call, get questions. Yes.
Welcome back. You can just grab whatever seat you want. I won't keep you much longer. We've got, Deputy, we have all the notes and.
Yes, sir.
Thank you. I want to just take a minute and thank you for your service. I was here for jury selection, and I know that some of you missed very important work engagements that you expressed meant a lot. Some of you missed doctor's appointments, and all of you missed personal time at work, with your friends, with your family, in sacrifice of your civic duty as serving as jurors. Contrary to what a lot of people think, I find this to be possibly the most stressful part of my job, because I now sit and look at all 3 of you who have given us a week and a half of your time, so willingly and so graciously, and to say, I'm sorry, I can't let you deliberate. Now, sometimes I do this, and you see the smiles come on people's faces, because they're glad they don't have to be part of the deliberations. And I have received some angry calls afterwards about being an alternate and the person wanted to go back and deliberate. However you feel, relieved or upset, I just want to say thank you for doing your civic duty, for answering the call, for being here, and just being so generous with your time. I've watched the entire jury the last 7 or 8 work days, and you have been incredibly attentive, paying attention. There's been a lot of people in and out of this courtroom. You have not been distracted one bit. You are exactly what we want in our jurors. and I thank you. On behalf of myself, the other judges of the 12th Circuit, thank you so much for giving us your time. I have some certificates of appreciation that I'm going to give you to commemorate serving as a juror. Also attached to each of those is the paper for work, if you need it to show where you've been for that. If for some reason that paper is not sufficient for your needs, please reach out to my judicial assistant. My card had her direct number, and if they need a letter from me or whatever they need, we'll get it to them to show that you've been here this entire time serving as a juror. I am now going to read you your final jury instruction. I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. The law gives you a unique privilege not to speak with anyone about the jury's work. Although you are at liberty to speak with anyone about your jury service, you are also at liberty to refuse to speak with anyone. It will be up to you to decide whether to preserve your privacy as a juror or not. With that said, again, I offer my heartfelt thanks on behalf of myself and the other judges of the 12th Circuit, all of the court administration, and for all the citizens of the 12th Circuit for being part of this process. I now discharge you as jurors in this case and release you from any further obligations in this matter. If any of you would like to be escorted to your vehicles, all you have to do is let this deputy know, and he will make sure that you are walked all the way to your vehicle until you leave. Thank you again very much.
Thank you, Judge.
All right, you all can have a seat.
Your Honor, if I may, what's the 12th Circuit's position about approaching alternate jurors to see if they will speak?
I'm not aware of an official position on our website.
I just want to make sure. Does the court have any,
Oh, you mean like interviewing them or just walking up to them?
just approaching them and asking if they would be willing to speak?
I would appreciate having a hearing on that.
Okay.
All right, anything else before we go?
We've got the JOA.
Oh, yes.
Okay, so on behalf of Ms. Benefield, we renew all previously made motions and objections, specifically our JOA. And now for the final, I would state that the state has failed to meet its burden of disproving self-defense beyond a reasonable doubt, and that the uncontroverted evidence clearly demonstrates that Ms. Benefield acted in justifiable self-defense. More specifically, she testified that Mr. Benefield physically intimidated her, prevented her from leaving the residence, struck her on the head, pursued her to her bedroom, and advanced on her in a threatening manner despite her warnings to stop. She reasonably believed, second DCA 1986, quote, "The state has the burden of proving guilt beyond a reasonable doubt, which includes proving beyond a reasonable doubt that the defendant did not act in self-defense. The state's evidence was legally insufficient to prove guilt beyond a reasonable doubt because the state failed to rebut the defendant's direct testimony that he acted in self-defense, and in fact, some of the state's evidence corroborated defendant's testimony of self-defense." Thank you.
Steve.
Judge, and I would just say that the state has met its burden, that a reasonable jury could find beyond a reasonable doubt that this charge has been proven. Would ask you to deny the JOA.
Any rebuttal?
No, sir.
All right, I'm going to reserve at this point. All right, if there's no other business, then we are going to be in recess until we have a question or a verdict. I would ask if you could please leave a cell number with the clerk so she has, so we can get a hold of you. Please don't be more than 10 minutes away so you can get back here pretty quick if we have any any questions or issues.
What time do you think you'll let them go to, Judge?
Go for the evening?
Yeah.
I tend to let them go until they ask to leave. The issue that's in the back of my mind right now is to see if they ask for dinner. What, do we have a cutoff for that? To order?
Court can offer to have something read back when they don't ask for it, but if it is read back, it needs to be the direct and the cross.
All right, any final thoughts? Because based on his observation or what Ashley told him, i.e. domineering, super controlling, alpha male, over the top, not genuine. All right. Anybody want to be heard first?
Any particular order?
No, sir.
I understand the question. What's the court's inquiry?
How do you, I'm listening for, I mean, I know in my mind how I think I'm going to respond, but I'm always going to give the parties an opportunity to be heard on
Sure.
that.
I think they should have Dr. Quintel's testimony read back to them, specifically because I asked Dr. Quintel if he reached any conclusions as a result of meeting and evaluating Douglas Benefield, and those were the conclusions that Dr. Quintel said he reached. It had nothing to do with my asking him if it was based upon anything Ashley Benefield told him. And I think unless that message is sent, unless that's clear to them, then I think it's a terrible prejudice to the defense.
I'm sorry, what's a prejudice to the defense?
What's the question?
No, what was the prejudice to the defense? If what happened?
Prejudice to the defense is that they're being misled.
If we do what?
If we do not read back their testimony, read back his testimony. That way it doesn't have to be the lawyer's comments, it's the testimony of the witness, it's objective.
Judge, I think there are a couple options. One is the standard use your memory. I don't know if the court can offer to have something read back when they don't ask for it, but if it is read back, it needs to be the direct and the cross.
All right, any final thoughts? Well, they clearly are not asking for a readback. They're asking a factual question. And I would direct both sides to standard jury instructions 4.3 and 4.4. 4.3 addresses answers to juror inquiries during deliberations. 4.4 is request for readback or playback or transcript of testimony. We've all done this long enough. This is not a request for a readback. If they want to read back, they say we want to read back. They ask for testimony. It happens all the time. So at this point, the appropriate response is going to come from 4.3.
What kind of
Wonderful. Wow. We'll get that one. No, Judge, my concern, Your Honor, is that we're just assuming they know that they can ask for a readback. And I don't know that that's a fair assumption.
In your 400 trials, when have you ever given when has a judge ever given an instruction, hey, by the way, you could ask for a readback?
No,
No, I haven't either.
no, but I don't know if they know that, and the question may be inarticulate, that Maybe you could ask for a clarification of the question.
Your Honor, Judge, we don't object to 4.3, we ask that you.
I'm sorry?
We agree 4.3 is the right.
Yeah, that's the
Thank
correct
you.
response.
Yeah, if you needed us to agree, we do.
Okay. No, it's not even a debate, that's the correct response, it's 4.3. All right, welcome back, everyone. We're back on the record in State of Florida versus Ashley Benefield, 2020 CF 3014. I have another communication from the jury. I'm going to read it verbatim and then I'll hear from both sides. Unable to come to unanimous verdict. Signed, juror.
That's an easy one. It's been less than 6 hours. Keep working. But with this caveat, Your Honor, I think you should at least acknowledge to them, because I don't know that either out of politeness or a sense of intimidation, I don't know that they know they can ask if they can go home and come back in the morning.
Judge, and I think asking them about going home and coming back is definitely something that they also need the Allen charge before we make any decisions after that.
I can give an Allen charge
Yeah.
after 6 hours.
Yeah, hold on. Just go ahead and say your piece.
Judge, I didn't realize that there was any hour attached to an Allen charge. I just thought that once they said they were deadlocked, that you give them the Allen charge. But it is almost 10 o'clock, so they may want to go home and come back tomorrow.
All right, thank you both very much. As we all know, the Allen charge is a one-time thing. So my inclination was to bring them out, acknowledge that they've been working for almost 6 hours, well over 5.5 hours, acknowledge the time of the evening, and give them that option. And I'm not going to ask for them to vote. The way I do this is I'll explain to them, you've been working, we acknowledge that, it's late. If you want, you can go home for the evening, come back tomorrow, fresh, and continue your deliberations. I send them back to decide if that's what they want to do or not, and then go from there.
Yes, sir.
Okay?
Okay?
All right, let's bring them out.
Right.
All right, y'all can have a seat. Welcome back. Members of the jury, I've received a note from you. It says unable to come to unanimous verdict. We all recognize that you've been working for almost 6 full hours, and it's getting late. It's almost 10 o'clock in the evening. I want you to go back, and there's an option that we can come back tomorrow and start fresh in the morning. I do have some court first thing in the morning, but we can get started same as every other day about 9 o'clock. So I'm going to ask you to step in the back and make a decision amongst yourselves if you'd like to come back tomorrow morning fresh to start.
Or there's no other option.
I need you to discuss that first, please. All right, you can all have a seat. All right, the response from the jury is "we will stay," signed by a juror. So we'll be in recess until we get another question or a verdict.
Yes, sir. Thank you.
All right, we're back on the record in State of Florida versus Ashley Benefield, 2020 CF 3014. I've been informed there's a verdict. Prior to bringing the jury out, I did want to make this announcement. The jury has reached a verdict, and I'm about to bring them out so the verdict can be reviewed and published. I know many of you here in the audience have been here throughout the trial, and I want to thank you for conducting yourselves appropriately throughout the trial. I realize that the reading of the verdict can be very stressful, and it is likely that some of you will agree with the jury's verdict, and some of you will not. As sometimes happens, it may be that no one is pleased with the jury's verdict. Whatever your personal feelings are about this jury's verdict, I ask you to remember that these jurors were randomly selected from our community. They were thoroughly questioned by the court and lawyers for both sides, and they were selected from the larger group to hear this case because of their demonstrated ability to be fair and impartial. I've paid close attention to this jury, and they have been attentive, observant, and focused throughout the trial. No matter how much you agree or disagree with the verdict, there are to be no outbursts of emotion. Our judicial system, in fact our entire society, has relied on jurors to help resolve disputes for over 200 years. Their verdict needs to be respected even if you don't understand it or don't agree with it. Are you ready to bring in the jury?
Yes, sir.
All right, bring them in. All right, you all can have a seat. Members of the jury, I understand you have a verdict, and we have a foreperson.
Yes, we do.
Ma'am, has the jury reached a verdict?
Yes, we have.
Is the verdict unanimous?
Yes, it is.
Would you please hand the verdict form to the deputy? I need to check it, make sure it's in proper form. Thank you. verdict appears to be in proper form. Madam Clerk, would you please publish the verdict?
In the Circuit Court of the 12th Judicial Circuit in for Manatee County, Florida, the State of Florida versus Ashley Benefield, case number 2020 CF 3014. Verdict. We, the jury, finds as follows as to the defendant in this case. The defendant is guilty of manslaughter, a lesser included offense. Did Ashley Benefield actually carry a firearm? Yes. Did Ashley Benefield discharge a firearm? Yes. Did Ashley Benefield, as a result of discharging a firearm, cause death to Douglas Benefield? Yes. So say we all this 30th day of July, 2024, at Bradenton, Manatee County, Florida. Cheryl Forkerson.
Would either side like the jury polled? State?
No.
Defense?
Yes, sir.
Members of the jury, you're now going to be polled. The clerk is going to ask each of you individually if this is your verdict and the verdict of the jury as a whole. Madam Clerk?
Juror number 15, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 20, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror 21, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 29, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Juror number 33, is this your verdict as well as the verdict of the jury as a whole?
Yes.
And juror number 35, is this your verdict as well as the verdict of the jury as a whole?
Yes.
Thank you. Members of the jury, I want to thank you for your time and consideration in this case. I know that many of you have missed important work obligations and family obligations and other engagements that you had planned, as well as time with your families. But I want to thank you for being willing to give us your time and your attention and being observant to this entire trial and serving as jurors and doing your civic duty. I have paperwork that we're going to give you that will reflect your service as a juror, as well as a piece of paper from the clerk's office documenting that each of you has been here for these number of days if you need it for work purposes. If you need some sort of other paperwork for work or anything like that, contact my judicial assistant and we'll be able to get that for you. I also want to advise you of some very special privileges that all jurors enjoy. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak with anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. Bless you. It will be up to you to decide whether to preserve your privacy as a juror or not. Again, on behalf of myself, the entire judges of the 12th Circuit, thank you very much for your time and your attention during this trial. I now discharge you as jurors in this case and release you from any further obligations in this matter. You're free to go. Make sure you pick up your electronic devices, and please make sure that your notes stay with the deputy. They're going to be returned to me. They will be destroyed. No one will ever read your notes. Thank you. All right, you all can have a seat. The jury is out. State.
Judge, I would ask you to remand the defendant at this point. I believe she has a right to a PSI for sentencing, so I'm not sure if she would waive that or proceed with that.
Do you want to PSI?
I think we'd prefer to have the PSI.
I'll sign an order tonight for that. It's a late in the evening. My judicial assistant will reach out to both of you tomorrow to begin coordinating a hearing, sentencing hearing. You could let her know how much time you need. Right now, the pre-sentence investigations are running a month to 6 weeks, so it'll certainly, the time for sentencing will be outside of that, but then you can let me know how much time you'll need.
Let me direct myself, Your Honor, to post-trial release if I can.
Yes, sir.
Under Youngston, I know that the Younghans, rather, I know that the court is familiar with the standard. They stated in no uncertain terms, but if taken in good faith on grounds not frivolous but fairly debatable in view of the decisions of the Supreme Court, then the petitioner should be admitted to bail. And they set out for the trial court 3 factors. The first, with respect to the appeal not being frivolous, I think by the court's own acknowledgement at 2 different points in the trial, the court noted that we were dealing with novel issues that the court had not seen before. I think we certainly have good and sufficient grounds to appeal in good faith. The factors, according to Younghans, Your Honor, is the habits of the individual as respect for the law. Ms. Benefield has no prior history of criminal activity, as the court knows. Her local attachments to the community by way of family ties, business, or investments. She lives here in Bradenton, has lived here for a while. Her mother resides here, her child resides here. The severity of the punishment imposed for the offense, that is substantial. There's no denying it. And any other circumstance relevant to the question of whether the person would be tempted to remove herself from the jurisdiction of the court. Ms. Benefield, on every single occasion over the course of the life of this case, has appeared when requested. She has never once failed to meet any obligation pursuant to the bond that she's on. As a result, we ask that the court entertain setting a post-trial bond. The only other thing that the court noted in the Younghans decision was that it's axiomatic that the exercise of judicial discretion should never be arbitrary, capricious, or unreasonable, and where the discretion is exercised in favor of denying to a person a basic and fundamental right, the reasons for doing so should be sound and they should be clearly stated. So pursuant to Rule 3.691, post-trial release, Your Honor, we ask that the court admit Ms. Benefield to bond, continue her on the same bond, in fact. And if the court is not inclined to do so, we ask that Your Honor stay the decision so that we can appeal directly to the 2nd District. As the court knows, it's an accelerated docket because of the nature of the motion, that is to say, the bond.
Thank you. State, did you want to be heard?
Judge, I object to any bond at this point. The potential sentence is 30 years. While this defendant may have appeared at every court hearing, she was not convicted of the charge at the time. She has much more at stake at this point, being convicted of this crime, and I would ask you to deny the bond.
Any rebuttal?
No, sir.
Ms. Benefield, the jury, having found you guilty of manslaughter with a firearm, are going to remand you to the custody of the Manatee County Sheriff. We're going to revoke your bonds where you'll be held pending sentencing. All right, the court will stay in recess until we get a sentencing hearing set up.
Thank you, Your Honor.
I trust Your Honor will issue a written order on the bond.
The bond?
Yes.
Yes. If it's required, I certainly will.
Thank you, Your Honor. Thank you, Madam Clerk. Thanks. Thank you.
I was built to last with the webs I'm weaving. I could change the past with all I'm achieving. Got my foot on the gas, never stop competing. If you break like glass, then this life's gonna end.
I wanna be the best in the game, invest in my name. Check no restraints, I'm obsessed with the pain. I ingest, I retain, assess and I change. Possessed by the thought I'll be free one day from society's restraints. Money, clout and fame, mud, disease, a plague. We all love to hate, have to play the game, have to make a name. All our insecurities are on display. This is war with the enemy, think that it was meant to be. Living in a time where disease is on every screen. I won't let them fester me, I know most are festering. Negativity is a plague for the mentally weak. No mercy, all I got is working. Never stop searching, never quench the thirsty. I'm toxic and psychotic, with this logic you can't stop it. It's been chronic since I was a boy, so neurotic and chaotic. Built to last with the webs I'm weaving. I could change the past with all I'm achieving. Got my foot on gas, never stop competing. If you break like glass, then this life's gonna eat 'em. Make mistakes real fast, then you learn how to beat 'em. If you take off the cast, you can see all the healing. If the pain's in the past, move on from the grave and put your foot on the gas. No, never stop competing, yeah. I've been doing this, I'm on it. I just wanna be iconic. Sipping on a gin and tonic, got me going off when I'm on this topic, yeah. If I ever play, I want it. You know that I'm always honest. Stay away from those who are toxic. Keep them out your face, no way, you don't want them, yeah. Don't try to drain my energy. The enemy is everything. It's mentally, unhealthily, spreading like a rare disease. But I won't let it get to me. I don't need your therapy. I can leave a legacy of leading by intensity. Come on, we can fight this. Freedom is priceless. Spread just like a virus. Living in a crisis. Do you feel courageous? Do you seek greatness? Trust me, you can take it. Go on and take your aim. Yeah. Built to last with the webs I'm weaving. I could change the past with all I'm achieving. Got my foot on gas, never stop competing. If you break like glass, then this life's gonna eat 'em. Make mistakes real fast, then you learn how to beat 'em. If you take off the cast, you can see all the healing. If the pain's in the past, move on from the grave and put your foot on the gas. No, never stop competing, yeah.
I was built to last with the webs I'm weaving. I could change the past with all I'm achieving. Got my foot on the gas, never stop competing. If you break like glass, then this life's gonna end.
I wanna be the best in the game, invest in my name. Check no restraints, I'm obsessed with the pain. I ingest, I retain, assess and I change. Possessed by the thought I'll be free one day from society's restraints. Money, clout and fame, mud, disease, a plague. We all love to hate, have to play the game, have to make a name. All our insecurities are on display. This is war with the enemy, think that it was meant to be. Living in a time where disease is on every screen. I won't let them fester me, I know most are festering. Negativity is a plague for the mentally weak. No mercy, all I got is working. Never stop searching, never quench the thirsty. I'm toxic and psychotic, with this logic you can't stop it. It's been chronic since I was a boy, so neurotic and chaotic. Built to last with the webs I'm weaving. I could change the past with all I'm achieving. Got my foot on gas, never stop competing. If you break like glass, then this life's gonna eat 'em. Make mistakes real